Yes.
May I please, Your Lordship? Today's item number 48, Lordship. It was disposed of by Honorable Justice Suman Shyam. So there are some typographical mistakes. Perhaps it may be listed before the appropriate court, Lordship.
Item
number 48.
Kamolesh Deka.
Kamolesh Deka.
Correction of the order.
Yes, Lordship.
Correction of
Let's
Lordship,
look for appropriate bench.
There are urgency, Lordship. Kindly maybe fixed on 27.
Next.
Lordship.
Next.
My lord, I'm mentioning item number 30 with the consent of the other side petitioner, my lord.
Here for the writ petition.
Writ petitioner, my lord. 30, my lord.
Yes.
30. My lord, PWD is supposed to file an affidavit, my lord. We have sent it for vetting. So, 2 weeks time, my lord, in 2 weeks time we'll file it.
Mr. Betala, any
No
objection?
No objection, Lord.
As prayed for by Mr. R. Dhor, Learned Steering Council, PWD, list this. As prayed, sorry, Honorable Kalidia. Mr. R. Dhor, Learned Steering Council, PWD, submits that the affidavit has been sent for vetting and accordingly seeks accommodation in the matter. Mr. H. Betala, Learned Counsel, appearing for the petitioner, does not oppose the said prayer. List after 2 weeks on a date to be fixed by the registry.
Highly obliged.
May I please, Your Lordship? Lordship, with concern of other side, Your Lordship, I beg to mention item number 25, Your Lordship.
25.
Yes, Lordship.
Yes.
In this case, Your Lordship, we have filed affidavit in reply. So, kindly attend this matter to this. And after
You are Akan.
Yes, Lordship.
As prayed for by Mr. S.I. Akan, Learned Counsel, for the petitioner, list this matter after 3 weeks on a date to be fixed by the registry.
My lord, in this case,
to enable the petitioner to file rejoinder to the affidavit in opposition filed by the respondents.
Yes.
my lord, may kindly fix it on 13th. Mr. I. Chaudhary is appearing. He has requested.
All right, it will come. Next.
So obliged. May I please, Your Lordship? Lordship, with the concern of the other side, I beg to mention item number 24, Lordship.
Yes.
Lordship, may kindly grant me for 2 weeks time, Lordship.
You are for?
N. Kalita on behalf of A. Kalita,
No,
Industries and
you are
Commerce.
for industries. Item 24.
Yes, Lordship.
You want to file any affidavit
No,
or
Lordship, we have
what?
already filed, Lordship.
As prayed for by Mr. N. Kalita
Yes, Lordship.
on behalf of Mr.
A. Kalita.
Kalita, Learned Steering Council, Industries and Commerce, which is not opposed by the other side.
Yes,
List this matter after 2 weeks on a date to be fixed by the registry.
Obliged.
May it please, Your Lordship. Lordship, with the consent of the other side, I beg to mention item number 15 of the daily list, my lord.
Yes.
And I pray for 1 week time to file a rejoinder to the affidavit in opposition.
As prayed for by Mr.
D. Golita, my lord.
You,
D. Golita.
D. Kalita, Learned Counsel, for the petitioner, list this matter after 2 weeks to enable the petitioner to file the rejoinder to the affidavit in opposition filed by the respondent.
Respondent AEGCL.
Respondent
AEGCL.
AEGCL.
Obliged.
Lordship, in item 55, we have filed an affidavit, Lordship, that same may be called for.
Call for. Yes.
May I please, Your Lordship? May I please, Your Lordship? Lordship, in item number 11, pleadings have already been completed.
Item 11, pleadings are completed.
Yes, Lordship. On the joint prayer, matter may be fixed in the first week of December. In
item 11, as jointly prayed by both parties, list this matter after 2 weeks on a date to be fixed by the registry.
Obliged.
Hearing BA, item 54.
আৰু এটা এৰি দেখিছো মাতি দিব সেইটো
Please,
yes
Lordship, this is an application for regular bail application, my lord.
I had earlier granted
Yes, Lord.
bail
Earlier granted bail to some other accused, my lord.
Co-accused, Lord.
co-accused
Yes.
right now. What is the stage of the
My lord, investigation
Trial?
trial is, my lord, trial going on. Vital evidence of vital witnesses were already taken, my lord, and 2 eyewitnesses implicated the present petitioner. Dying declaration was also proved, my lord, by PW7, and my lord, very heinous offense of acid attack, my lord. One, my lord, minor girl, my lord, He, my lord, expired ultimately after 20 days of our fight, my lord, for Cyberbell. He ultimately expired on, my lord, GMCS on 11/12/23 after 20 days of the incident. And one another, my lord, victim, she was also grievously injured, my lord. And during trial also, my lord, till now.
Mr. Bhattakur, is this court convicting the accused?
No, I am not saying, because trial is going on, my lord. During trial,
Yes, so now please let us be focused to the factors which are required for consideration of grant or not grant of bail.
yes, my lord, from
Number one, you said vital witnesses have been already examined.
taken, my lord.
And out of that, two eyewitnesses
Two
have
eyewitnesses.
implicated the petitioner, right?
Petitioner. And
What
the-
about the antecedent of the petitioner?
My lord, regarding antecedent of the petitioner, there is no such
No adverse
but,
as of.
but considering the
This is the
heinous,
first time.
yes, my lord. No, my lord. One another case is also registered against the accused for, my lord, against my lord, Child Marriage Act, my lord. That is also Borpeta PS case. My lord, that number is also there.
553.
Yes, my lord.
Where is the
And in
FIR?
the manner, my lord, how he committed the, my lord, offense, my lord.
Gravity, I understand.
Yes,
Acid attack is not a very
And otherwise
offense
from
to be
the-
lightly taken.
And
I
yes,
understand that.
Otherwise,
But,
my lord, from the evidence, my lord,
But
witnesses.
that is why I asked you,
Yes.
am I convicting him?
No, my lord, because from
Let
the
us see the FIR.
Page 9, my lord.
Page
9.
total, how many witnesses are there?
57 witnesses, my lord.
57. How many has been
Those are
examined?
those are listed witnesses, my lord. No, already vital witnesses were already
No,
taken.
that you have already said. But out
Yes,
of
ma'am.
57, how many has been examined?
My lord, 22 witnesses already, my lord, examined.
And those 22 are the vital witnesses.
Vital witnesses.
Now probably the official witnesses are left, or the
yes,
Caesar witnesses.
Yes. And my lord, from these witnesses, my lord, from the, my lord, LCR, my lord, it reflects the sons of acquittal is almost nil, my lord, because, my lord, her dying declaration was also proved by the doctor, my lord,
Okay.
before whom that was recorded, my lord.
This is the first time you have come.
Yes, Lordship.
How many days?
Lordship, almost 1 year, my lord. He was arrested on 23/11/2023.
23?
11/2023.
I think for length of
My
delay.
lord, considering, my lord, length of detention is this type of offenses, my lord, how one minor, my lord, girl was
Mr. Bhattakur, 1 year he has.
My lord,
is in the
why I am
jail.
saying, your
now,
lordship?
now it appears that the trial is going to take further time.
Yes.
Because only 22 out of 57 has been.
No, my lord, all the it
examined.
is not required to take evidence of all the witnesses, because vital witnesses,
That
those
we
are
don't
listed,
know.
because
That we
those are
don't know,
listed
Mr.
witnesses, my
Bhattakur.
lord.
That we don't know.
But, my lord, from the, my lord, records, my lord, the evidence or deposition of those witnesses, my lord, and the dying declaration on the basis
That
of that,
I've
my lord,
understood.
almost
That
the sons
there
of
are
acquittal is
implications.
almost nil, my lord.
And according to you, the evidence that has by and large come now
Yes, my lord.
almost makes out a case
Yes,
of
my lord. Only on- yes,
guilt.
Yes, only on the basis of dying declaration, my lord, which was in fact proved by PW7. My lord, from all these evidences, sons of acquittal is almost nil, my lord. So at this stage, on the ground of length of
Please
detention,
take
my lord,
down. Heard, Mr.
MM Jaman, Lord.
M.M.
Jaman, Lord.
Jaman, learned counsel appearing for the accused petitioner, as well as Mr. P. Bhattakur, learned APP Assam, appearing for the state respondents. By filing this, this petition is filed under section 483
483
of
BNS.
BNSS 2023 for granting regular bail to the petitioner, i.e. Rafizul Islam, alias Rafizul Ali, alias Babu, who was arrested on 23/11/2023 in connection with Sessions case number 8 of 2024 being registered under section 341, 326 capital A, 307, 302, 34 of IPC, arising out of Borpeta PS case number 553 of 2023, pending before the Court of Learned Additional Session Judge within bracket FTC Borpeta. Stop. The facts, the case of the prosecutrix is that accused number 1 is you, right?
Yes,
That is that the complainant's 17 years old minor daughter and the accused petitioner were in love relationship, and the petitioner accused
In fact, my lord, they were already.
on 19/11/2023 at around 8 p.m. along with co-accused came in a four-wheeler and forcibly tried to kidnap the complainant's two daughters and when the complainant tried to stop them, they threw acid to both the daughters' body, for which they were seriously injured. Stop. Accordingly, an FIR was registered. Stop. Mr. So-and-so, learned counsel for the petitioner, submits that the petitioner has been languishing in jail since last almost 1 year. He further submits that the trial has commenced, and out of 57 witnesses, 22 has already been examined. 22 has already been examined. Stop. He further submits that the petitioner is innocent and co-accused has already been granted bail earlier by this court by order dated 25/2024 in bail application 1279 of 2024. Stop. For contra, Mr. P. Borthakur, learned APP, vehemently opposes the prayer for bail. Stop. He submits that the case is heinous in nature, and from the evidences adduced, it has clearly come out that the petitioner has thrown acid to the two daughters, for which they have been seriously injured,
Injured and ultimately expired, my lord.
and one is expired.
Expired, my lord.
And one of the daughter has also, in the meantime, expired.
Expired on 11/12/23.
And one of the daughter thereafter has
Nirupa.
expired on
11/12/23.
11/12/2023.
23, my lord.
Stop. He further submits that a perusal of the evidences by and large adduced so far clearly indicates that a case of clearly indicate that it is unlikely that the accused shall be acquitted. Correct?
Yes.
Stop. I have heard and perused CD. It appears that the petitioner was arrested on 23/11/2023 and since then has been languishing in jail, which is almost 1 year.
1 year.
Almost 1 year. Stop. It further appears that vital witnesses have already been examined by the trial court. It further appears that two of the eyewitnesses has implicated the accused for the alleged offense.
Yes.
It further appears that in view of the dying declaration, a clear case of conviction is being made out against the
Yes.
accused petitioner.
And my lord, dying
It
declares-
further appears that out of 57 witnesses, only 22 has been till date been examined by the trial court. Stop. It appears that the trial is likely to take some time. Undoubtedly, the offense is grave and heinous, No, it further appears that no adverse antecedents has been collected against the accused by the investigating officer. Stop. Undoubtedly, the offense is heinous and grave. However, this court is not. However, this court is not considering conviction of the accused petitioner at this moment, and is only considering whether to set the petitioner on bail or not. The object of bail is to secure the attendance of the accused petitioner throughout the trial. Stop. Considering the length of delay and no adverse antecedents having been collected, this court is of the considered view to grant bail to the petitioner. Accordingly, it is provided that the accused petitioner named above shall be released on bail of rupees 50,000 with one surety or two surety?
Two surety, my lord.
With two sureties
And my lord.
of like amount to the satisfaction of the learned additional session judge within bracket FTC Borpeta, subject to the following conditions. Number one, appear before the trial court on all dates to be fixed from time to time till the case is disposed. Directly, indirectly inducement. Number two. Number three, refrain from committing similar offences. And number four, you passport.
Yes.
And not number five, not leave the jurisdiction of the trial court without prior information. This disposes of the bail application.
Highly obliged, Lordship.
Item 51 for motion.
Let please, your lordship.
AB,
Lordship.
I have dealt with a similar.
No, lordship.
Then why is it before me?
I don't know, lordship.
Huh?
I cannot say, lordship, but why?
No, then it should be listed
And
before the.
lordship, and another thing, lordship, there are 12 numbers of accused, lordship, in this FIR. So if earlier is by this honorable court is
Mr.
granted,
Bhattacharya, just have
not
a
able,
look. I think that
yes,
index funds are good. Till then, you call the next matter. Mr. Bhattacharya, just have a look if I have dealt with any co-accused.
no such order.
No, just see the index. It is referring to one case.
Yes.
So have a look. Let me take another matter till then.
Yes.
Order stay vacating item 1.
Obliged.
Lordship, in this case, Mr. J. Patwari is on legs, just timing for.
Hmm?
So J. Patwari is on legs for the timing. Maybe
Timing?
Timing.
Implement of party. Item 2.
New incumbent.
Lordship, it's not implement of party, although I have filed this for deleting from the area of respondent. It's not for implement of party.
So it is wrongly
Yes,
listed
Lordship.
under the column
column
impediment of party.
Yes, Lordship.
You want to be deleted from the contempt proceeding?
Yes, Lordship.
On what ground?
Lordship,
You are the petitioner.
I'm the petitioner.
Yes.
Lordship.
Why should this court delete your name from the arrayed respondents?
Yes, Lordship.
Are you not a party to the writ petition?
Lordship, the person whom he is arraigned by name, he is not the post which was hold.
He
I
was
have
not
stated-
holding that post.
Yes, Lordship. He is not holding the post. Or neither he had received any document regarding that contempt
This
proceeding.
has come for the first time.
Yes, Lordship.
You have any objection?
Yes, we'll file our objection.
Then you file.
Before coming to that, my lordship, kindly have a look. The affidavit part, my lord.
If you are filing an objection, you file it. Affidavit, yes. What do you want to show? Paragraph is
He
nil.
himself saying, my lord, R.K. Pal is the presently serving as a deputy inspector headquarter. He himself is serving. And para 4, my lord, he said he is not working.
Correct. You take your
Yes, yes, sir. 3
objection.
weeks time be granted.
Item number 2, heard MSB Sharma for the Learned Counsel for the applicant. Stop. Also heard Mr. J.I. Borboya,
Borboya.
Learned Counsel for the respondent
Petitioner.
petitioner. Stop. Issue notice, returnable
After 3 weeks.
3 weeks. You are appearing for all the respondent.
I'm the sole respondent. I'm the petitioner.
He is the petitioner.
You are Vikram Singh.
My lord.
What about Ajay Kumar Bhatia and Abhishek Anand? Anybody appearing?
Yes, Lordship, for respondent number 3, I have already filed my affidavit.
You are appearing.
Yes. In the
You are appearing for the applicant and the respondent.
he is also the respondent.
Ms. Counsel, this application is done.
One of the
is filed-
contemptors.
Correct. And in that is Mr. B.K. Pal, right?
Yes.
Now, in there, you have two pro forma opposite party. How can you appear for both petitioner, applicant, and the respondent?
Because I have to show them as a party, Lordship.
You may have to show them a party, but how can you appear for both? You please check it out, Ms. Sharma. You please check it out, because since now you have filed it by way of an application, and you are the counsel for the applicant, whether you can also appear for the pro forma opposite party. Do check that position.
Yes.
I am not clear with that, because my conscience says you may not be able to. There may be a conflict of interest, because both are in different sides. Maybe pro forma, nonetheless, is in the respondent side. May not be a potential conflict, but some conflict could be there. You have a look at it. Mr. J.I. Borbhuya accepts notice on behalf of the opposite party 1. Extra copies within 2 days from today. Registered steps in respect of 2 and 3. Within 3 days, after 3 weeks.
Item 3 for admission.
Lordship, kindly peruse the last order, my lord, 4/11/24.
Yes.
Records and decision has been called
Repetition
for.
is premature. Then, Mr. J.K. Goswami.
My
Shall
lord,
obtain instructions.
yes, that instruction is still awaited, my lord. Yes, my lord is referring to order in 4/11/24, my lord. My lord will grant me some time and I will take it up with the government.
As prayed for by Mr. R. Dhor, Learned Counsel, for your appearing for Mr.
As the government
Dhar.
counsel, my lord.
Huh?
As additional senior, my lord.
Learned Additional Senior Government
1 to 7.
Senior Government Advocate for the State of Assam, list this matter after 2 weeks to enable the said respondent obtain the instruction as earlier called for by this court by order dated 4/11/2024.
Lordship, may kindly fix the date. It is a long pending case, my lord. On
Yeah,
16th of December.
Okay, give a date. Mr.
16.
Dhar, I'm giving a date, huh?
My lord.
6 is it?
Obliged.
Item 4.
May I please your lordship? 2018 matter, my lord. And
Yes.
issue involved is a very small one, your lordship.
How come no affidavits?
Since 2018, my lord. And
Appointment?
yes, my lord.
Raubura?
Yes, he will be overage, perhaps.
Yes, Mr. Dhar.
My lord,
Issue is very.
it is gone for betting on 3/10/24. I will check it up, my
You
lord.
please check it up.
Yes, yes.
Mr. R. Dhar, Learned Additional Senior Government Advocate, submits that the affidavit in opposition has been sent for vetting and accordingly seeks a short accommodation. In view, and accordingly he assures that the same shall be filed within a week from today. In view of the aforesaid assurance given by Learned Additional Senior Government Advocate, list this matter after a week on a date to be fixed by the registry.
Time being item 1.
This is our stay vacation application. This has come for first time. We'll need to file our objection to it, my lord.
First time.
Yes, Lord. Today is the first time.
3 weeks time may be granted.
I issue notice. Heard Mr. S.N. Tamuli,
Yes, Lord.
Learned Counsel for the petitioner. Stop. Also heard Mr. J. Patwari, Learned Counsel, appearing for respondent number.
The opposite party.
Opposite party stroke writ petitioner. Health, anyone there? Health,
Department.
health.
A. Chalia was there.
Chalia.
A. Chalia.
And also heard Mr. A. Chalia, Learned Standing Counsel, Health. Mr. Fukan, please inform Mr. Chalia. This is an application seeking modification and vacation of the interim order dated 21/6/2024 passed by this court. Issue notice, returnable 3 weeks. Who accepts for whom?
My lord, I am accepting
Mr. A. Chalia, I think let us start from 1.
Yes.
Mr. Dhar, please have a look at the cost title.
One number, item 1.
Here is the question.
Item
One.
One is Mr.
Mr. Chalia,
Actually, I
you will be accepting
Help-
for
help-
1, 2, 3, 4, 5. Director of Health Service?
Yes, Lordship.
5. All right. Mr. A. Chalia, Learned Steering Council Health, accepts notice on behalf of respondent number 1 to 5. Mr. J. Patwari for 6 to 9.
12.
6 to
12.
6 to 12.
My lord, this is IA, there twice.
6 to 12. What about 13?
13, she is also in the original read petition. She is also a respondent. He is appealing.
And for
And
respondent
Mr.
number 6, D. Sharma.
Mr. So and so accepts notice for respondent number
13.
13. Extra copies within a period of 2 days from today. 2 days is holidays only. 3 days.
Yes,
3 days. List returnable key postal.
Lordship, a date may be fixed.
3 days. List 3 weeks from the date did you?
12 December.
Much of this.
Deep level.
Typing item 51.
Yeah.
My lord, earlier the petitioner, your lordship, has rejected by AB number 3480/2020.
Then I issue notice. You in the meantime have the case diary, because if I have rejected earlier.
And lordship, I'm sorry, lordship, but one submission, lordship. And earlier rejected, I have no knowledge, lordship, and so in this petition, lordship, I could not annex the earlier reject order, lordship.
That's all right. You have a look at it.
Lordship.
I am only asking them to have the case diary.
Lordship.
This is anticipatory, isn't
Anticipatory. But otherwise, lordship, in this case, lordship, charge sheet already been submitted, trial proceeding already going on, lordship. But for a moment,
Then they will have to
apparently,
my
lordship,
lord,
the
file new bail petition by mentioning all those CS number and everything. my lord.
it? File all that.
lordship.
Should I say for case diary?
No, my lord, already he has stated that already charge sheet submitted. Then, my lord,
Charge sheet submitted, trial already going on,
So
lordship.
where are those details? Where have you stated?
Lordship, I have still kindly come to page number, lordship, and the 16, lordship. 16, lordship. And the charge already been framed, lordship.
then my lord, LCR may
But
be
I am,
called.
lordship, the petitioner is shown absconder in the charge sheet, lordship.
All right. Let the records of the trial court be called for through the registry of this court. List. This is coming from where?
Nogao, lordship.
Nogao. Next week or no, last or Falana did it.
Obliged, lordship. Obliged. Obliged.
Item 5.
May I please, your lordship? Lordship, the present writ petition is against the penalty order imposed on me by way of a departmental proceeding. Lordship, my challenge to the whole penalty order stands on 2 footing. First, on a parity with the other delinquent officers, and the second on the perversity. So, lordship, I would like to address on the first point. I have prepared based on the records, I prepared a small compilation which will be helpful for educating the whole thing. If lordship allows me the.
This matter will take some time, I think.
If the first proposition is accepted, that will not take time. I'd just like to show it's a small. Otherwise, if the perversity has to be dealt with, that will take time. So, lordship, what has happened is that before looking into it, lordship, I am the field officer. Above me is the sanctioning officer, and above me is a controlling officer. Now, the charge sheet of all these 3 officers are identical. Like, I'd like to show that part first, the charge sheet. Lordship may go directly to a page 2.
Page 2 of
Page
this
2 of this
compilation.
compilation, yes.
Yes.
This is the articles of charges Lordship has got.
Yes.
Lordship, if I may read. During your tenure as chief manager at Dodora branch from 19/9/2017 to till date, certain serious irregularities were alleged to have been committed by you, and due to your such irregular activities, the bank is exposed to suffer a pecuniary loss of 205.31 lakhs besides reputational loss. You have failed to discharge your duties in the desired manner with due diligence and utmost sincerity as per bank's extant norms and instructions. These acts are unbecoming of an officer. In this manner, you have violated Rule 54 of the SBI Officer Services Rule that is applicable to you. Imputation of lapses on the basis of which the aforesaid charges are based are furnished in the attached Annexure 2, and the list of documents, witnesses on which the bank would rely upon to prove the charges are given in Annexure 3. This is the charge of one delinquent officer. Lordship may then turn to page.
I think
60.
this matter will need a full-fledged hearing, Mr. Counsel.
Lordship, since 2020, can it be listed next week, Lordship?
Not next week. This is item 5. No? You are Mr.
RJ Das.
RJ Das. Heard Mr. RJ Das, Learned Counsel for the petitioner. Also heard Mr.
H. Buragohai.
H. Buragohai, Learned Counsel, appearing for the respondents. All respondents?
Yes.
Respondent bank.
Respondent bank.
For the respondent bank.
All respondents.
Stop. Pleadings are completed. The matter requires full-fledged hearing. Admit.
Lordship, it is already admitted. Then it was only for this point.
No,
only,
but it is listed today for admission.
Yes, Lordship. But what has happened is that the hearing is started, and on this parity point, it was listed in the admission column. So I pray, Lordship, that because here the parity point, all three delinquent officers say verbatim charges. Others have been given a much lesser punishment, and I have been given removal of service, dismissal from service, which does not even entitle me for pension.
It appears that this writ petition was admitted on 3/6/2022. However, it has been wrongly listed today in the admission column. Let this matter be listed for hearing on any next week on any date fixed by the registry.
Deeply obliged.
Mr. Counsel, you can take this compilation back today. You can hand it over on the next date. Otherwise, it might just get lost.
This is with regard to the grant of minimum wage to the
Yes,
state
Mr.
workers.
Doctor.
Grant of minimum wage.
Minimum wage.
Yes, in fact, on 16/9, your lordship had asked them to clarify certain things. 19/6. Sorry, 16/9.
Also, we will be filing our affidavit today, Lord. Additional.
Today.
Yes.
Let me just have a look. What was the order that this court has
They claim that we are part-time
clarify
workers.
the stand.
Yes, they said that we are part-time workers. So your lordship wanted them to
Let them
clarify.
file it. They're filing
If
it.
they're filing today, it's fine.
Mr.
She Sharma.
C. Sharma, Learned Counsel. You're Learned Counsel for
Water Resources Department.
Learned Study Counsel.
No, Lordship.
Learned Counsel appearing for the Water Resources Department submits that an affidavit in opposition in terms of this court order dated 16/9/2024 is going to be filed during the course of the day. Stop. In view of the aforesaid endorsement made by the Learned Counsel for the respondent, list this matter.
Next week, Lordship.
Pray for a date, madam.
Huh? Did you at a date on such and such date?
Oblige, Lordship. Oblige.
Oblige.
Item 7.
Pension. Mr. Dhar.
No, my lord, I was even wondering why no affidavit was filed. Then,
Correct.
my lord, I saw, my lord, here actually BTC is the main party, and I think BTC was not served with any copies, or their name is not shown in the cause list.
BTC is party.
BTC is the main party, my lord. Cause
No, but they are party respondent arrayed or not?
arrayed, my lord.
Their name is not shown.
Not so.
Mr. Mahmood,
2 and 3.
BTC has been served.
No, my lord, their name is not in the cause list.
Oh, they are there otherwise.
2 and 3.
2 and 3.
Yes.
Let it be listed next week by reflecting their names. It appears that the name of BTC is not reflected in the cause list. List this matter again next week on a date to be fixed by the registry by reflecting the name of the standing council BTC in the cause list. All right, next.
BTC, yeah, BTC.
Yes, return.
No affidavit has been filed by the.
That is what it appears. Yes, Mr. Dhar.
My lord.
You sought time to file return on the last occasion. That was on 3rd of October. More than a month.
Yes, my lord. My lord. It has gone for vetting, though. Thus. My lord, instruction received, my lord. Instruction, it has come, my lord.
Mr. Ardhor, Leonard Standing Counsel, PWD submits that he has received instruction in the matter and assures the court that the same shall be filed by way of an affidavit within
10 days, ma'am.
10 days from today. In view of the aforesaid endorsement made by Leonard Standing Counsel, PWD lists this matter after 2 weeks on a date to be fixed by the registry. In the meantime, petitioner may file rejoinder if so advised.
Item 9.
May I please your lordship? My lord, this is an application, my lord, second Mohammedan wife and her minor children for apportionment of the pensionary benefit of her husband, my lord. My lord, the order was passed earlier. Accordingly, the petitioner filed. The officer concerned has already passed order for distribution of the same. Asked for some document to we have to submit. We have also collecting the documents. We are going to submit it. And I have an additional prayer that the money taken by the first wife, my lord, by cheating us, by misrepresenting.
You are the second wife.
By the first wife, my lord.
No,
I am
you
the,
are the
I am the
second
second
wife.
wife, my lord. So, my lord, I have to file an additional affidavit in this regard, my lord.
You want some time for filing additional affidavit.
Some the new development took place to bring it to record.
All right, you bring it as prayed for by Mr.
A.K. Talukdar, my lord.
A.K. Talukdar, Leonard Counsel for the petitioner, lists this matter after
2 weeks, my lord.
2 weeks to enable the petitioner to file an additional affidavit to bring on record certain developments that has
yes.
in the meantime taken place.
Date may be fixed, my lord. I'm for respondent number 11 and 12, my lord.
All right, date.
My lord, my presence may be recorded. 11 and 12.
Please give your appearance slips and
Online.
Item 10.
Yes. Mr. Barpujari.
Lordship, in this matter, my lord, they had filed their cost title, my lord, but it's not shown in
Our names are not reflected in the cost list.
Names not reflected.
not reflected, my lord.
Mr. Fukan, your name is there.
I am for the GAD, my lord.
We have
And
filed the amended cost
whether
title.
they
Finance not there.
not them.
Whether they
We
have
have
some
filed the
copy
amended
or
cost
not.
title, Lordship. We have filed the amended
No,
cost
that
title.
is right. But you see, the cause list does not reflect the name of Standing Counsel
Perhaps-
Finance.
Yes, Lordship.
Perhaps, my lord, after filing the amended cost title, they might not have served copy on us.
Yes.
I may be served with a copy of the.
That is also not given.
Served, Lordship.
Perhaps not given. Therefore, my lord, name is not reflected in the cost list.
No extra copy is not given to you.
No, because finance is newly implemented. So
But
I
there's
am
no,
entitled-
Yes, sir.
on the last occasion, there is an order. However, extra copies of writ petition be furnished within 1 week to you since Mr. R. Pujari, Leonard Standing Counsel Finance appears.
Perhaps, my lord, they have not served. Therefore, it is not.
Anyway, I am not recording all
Fine.
this. You serve a copy to the finance. I will direct relisting by reflecting the name of finance. All right.
I am so obliged.
It appears that the name of Mr. R. Burpujari, Leonard Standing Counsel Finance Department is not reflected in the cost list. Relist the matter when? Next week?
Lordship, a date may be fixed, Lordship.
Yes, next week.
Next week on any date to be fixed by the registry by reflecting the name of the Standing Counsel Finance Department.
2nd December.
Second.
Will be obliged.
Much obliged.
2022.
Yes, Mr. Nair.
May it please your lordship. Lordship, in this matter, I had served as an electrician, my lord.
Electrician.
Electrician. I was promoted to the post of junior engineer just 2 months prior to my retirement. My lord, I was not allowed to work as a junior engineer. They always addressed me as an electrician. However, my lord, they asked me for verification of my date of birth, which I had submitted my PAN card, Aadhaar card, and other documents. However, my lord, they bring in one particular document which is not mine and say that my date of birth is incorrectly entered. And I have not been paid my salaries or pension, my lord. My lord, my date of birth is 1st of July 1962.
Salaries not paid since when?
My lord, for 3 months, my lord. February and June 2022, and my lord, July 2022.
Who is your counterpart?
Irrigation, my lord.
Huh?
Miss Leog was appearing.
Irrigation.
Irrigation.
Yes, there is irrigation. You wait for some
My
time,
lord.
then, Mr. Nair.
My lord, my lord.
আহিলে দি কল কৰিলে হ'ব।
Deep privilege.
Item 30.
Dearness allowance, no affidavits. Mr. Barpujari.
Yes, my lord, we have just received the instructions and seeking 2 weeks time to file my affidavit.
Mr. Barpujari, Learned
Finance, my lord.
R. Barpujari, Learned Standing Counsel Finance,
My lord.
submits that he has received the instruction and accordingly assures that the same shall be filed by way of an affidavit. Stop. In view of the aforesaid assurance, list this matter after
2 weeks.
2 weeks on a date to be fixed by the registry.
I'm so obliged.
14.
Please, Your Lordship.
Yes.
Your Lordship, the last occasion, 24/7/2024, Lordship.
Mr. Bora was supposed to apprise the up-to-date status.
Lordship.
B. Bora.
Yes, ma'am. He is in port number 1, ma'am. He's on like.
You wait for some time.
My lord, in
Yes.
this case, my lord,
Washing.
no, this is my lord against the land grabbing act, my lord. So here, my lord, the newly implemented party 4 and 5, the elementary, my lord, commissioner and secretary, my lord. They are have been implemented and copy has been served, but no affidavit has till today.
Who is appearing for them? Elementary education. Mr. Fukan, you are there?
I am in elementary, my lord.
No,
but,
the
school education, my lord. I'm sorry, my lord, school education. Commissioner Secretary, Governor Assam, Department of School
Correct,
Education.
but I think Standing Council Elementary Education Department.
My lord, I'll get my instructions, my lord.
You have
Actually,
it and you file an affidavit.
I'll do that.
Mr. A. Fukan, Learned Standing Council, Elementary Education Department, enters appearance on behalf of the newly implemented respondent number 4 and 5 and seeks 2 weeks time for filing return in the matter. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry. Mr. Mohanto, you give him the extra copy. That would facilitate
Yes,
the
I'll
pleading.
already I'll copy. Deeply obliged.
I will be allowed to file additional affidavit in this case.
File?
And additional affidavit in this case, my lord.
Additional affidavit?
Yes, your lord. Some important marks have been missing.
No, but first of all, why have you not released the salaries?
As well as provisional pension, my lord.
Why salaries have been stopped?
My lord, as part of my instruction, he is appointed. He manipulated some documents and appointment has been taken, my lord.
I cannot hear you, ma'am.
He manipulated some documents and take appointment.
If he is manipulated, then you hold an inquiry in terms of law and
Yes,
take
madam.
action. What is this stopping the salary? You can place him in suspension, give him his subsistence allowance.
He's already
There are many things that you can do.
But I have retired the
No,
profession.
Mr. Nair,
Yes,
I am
my
just
lord. My lord,
reacting.
my lord.
I am not saying anything.
My lord, my lord.
You see, you cannot simply stop the salary on the plea that he has manufactured document. You will have to follow the law.
Yes, your lord, sir.
Right.
My lord.
This is what.
My lord. And my lord, the provisional pension also I'm entitled to. That also they have not released.
This is not correct. How much time? I'm giving you a short time to file the additional
Yes,
affidavit
sir.
because
1
you
week, your
cannot simply stop the salaries and pensions merely on the ground that some document submitted is manufactured. If it may be that I do not know the correctness of that
Yes.
document, but you will have to follow the law. You cannot simply block it. You
One
hold an
attempt.
inquiry
Yes, sir.
as prayed for by
DS New Irrigation Department.
MSDS Nyog,
Yes, sir.
Learned Standing Council,
Yes,
Irrigation
yes.
Department, list this matter on such and such date to enable the said department file the additional affidavit as requested. Stop. It is needless to be clarified since the matter involves
Payment of pension.
payment of pension and
arrear salaries.
arrear salary. The additional affidavit as the additional affidavit shall be positively filed by the next date of listing.
Date of listing.
Date of the date.
Deeply obliged.
Item 17.
May I please, Your Lordship? Lordship, the brief background of this case is this: that the petitioner was arrested when he was serving as the Superintendent of Police, Karimganj, in the year 2020 for charges of leaking question papers relating to sub-inspector recruitment exam. So later on, Lordship, when he was in the jail, a criminal trial started, and when he was in the jail, Lordship, the respondent authority started with the departmental proceedings. So the petitioner is here before this honorable court because the departmental proceedings and the criminal trial, they are based on similar facts, Lordship. So Lordship, after on the last date, Lordship, this honorable court had asked for an affidavit in the form of an affidavit, the number of witnesses relating to the petitioner.
Criminal case.
In the criminal case, Lordship. So, Lordship, the respondent authorities have filed an affidavit, but they have not specified the number of witnesses, particularly which is related to the petitioner.
Mr. Deenat, I think, is appearing, Mr. Dhar.
Yes, Mr. Nath is here, but we have filed our affidavit, my lord. It's specific, my lord. I have gone through the affidavit, my lord. I will call my friend, my lord. Deenat, no.
No, if you are
No, my
for
lord.
this court, you are. It is just I saw his name. That's why I referred.
Yes, my lord.
Otherwise, it's
Yes,
all
yes.
right, Mr. Dhar.
He is looking over the case. Otherwise, my lord, we have filed the affidavit. But the issue here is, my lord, the thing is that,
If I have understood correctly,
my lord,
is that on the basis of the similar allegation in the FIR, the disciplinary proceedings have also been initiated.
Yes,
Correct.
yes.
Now, both the criminal and disciplinary is going on. Now, perhaps this court wanted to see whether the witnesses are also same in both. Huh?
No, Lordship. This honorable court wanted to see that how many witnesses are left regarding
So as to have a perception as how much more time the criminal case is going to take.
yes, my lord.
Lordship.
Tentative 20 months, my lord. That is what we have said in our affidavit.
They have said it.
But 20 months for Lordship, if Lordship may kindly peruse the affidavit
Yes.
filed by the respondent authorities at page number 193.
One
Lordship.
second. Before that, I go. The order that you are saying is 1411.
Yes, Lordship. 1411.
No, not 1411.
No, before
20 to
that,
10.
Before that.
1411, my lord.
No, to play so as to. I think it's 20 to 10.
Yes,
Yes.
Lordship.
It would be necessary to ascertain as to the number of witnesses that the prosecution intends to examine so as to prove the charge brought against the petitioner in the pending criminal proceeding, and also the projected time frame. So two things were asked: number of witnesses and projected time frame. Now, where is the affidavit?
At page number 192 and 193, Lordship. 192 and 193 starts from 192, Lordship.
Yes.
Para 3. Lordship, they are saying that there are total number of 208 witnesses are there.
One second. Paragraph
3, Lordship.
Yes.
So they are saying that, Lordship, that the deponent respectfully states that as per information furnished by
No,
Sri
this
Durga
is not
Prasad-
the affidavit at page 193.
My lord, it is 202. Running page.
running page. They have provided me 191, 192.
202, my lord.
202.
Yes, my lord. My lord, I'm reading for the second
There
time.
is no 202 in my brief.
My lord, it's corrected by the registry.
I have only 200.
My lord,
Which is this affidavit. That affidavit is dated.
Affidavit dated Lordship
14/11/24.
2024.
No, that affidavit I think has not come on record.
Oh.
So Sahane. Yet lekha ase, but I don't find it here. That lekha to ase index. It has not come on record next week. It appears that the addition. Respondent 2.
Yes, my lord. Respondent
Respondent 2.
Yes, give me paragraph 3. Yes, read.
Lordship has found it. Yes. So it reads like this: that the deponent respectfully states that, as per information furnished by Sri Durga Prasad Jaiswal, Special Public Prosecutor of CID, PS case number 21 of 20, corresponding to special case number so and so, which is presently under trial in the Court of Special Judge Assam Guwahati, a total of 208 witnesses have been listed as prosecution witness in the case. However, after going through the statements of the witnesses recorded under section 161 CRPC and the material available, the special PP has identified about 150.
What more details do you need?
No, Lordship. This 150 number of witnesses are not related to the petitioner, Lordship.
That whatever, but they have, in terms of this court's order, they have already given, and they have also indicated the time frame. This court wanted to know how many more. They are saying a total number 27 important witnesses have been examined so far, and the prosecutor, and out of which the total is 208, and they have identified about 150 material witnesses. All the details are there.
Yes,
Lordship. If I humbly submit, Lordship. The thing is this, Lordship, that as per my instructions, Lordship, around 10 or 12 material witnesses relating to the petitioner are left. So, Lordship, if that number of witnesses are examined, after that
You file your reply.
Lordship.
How can the court take cognizance whatever you are saying? The official witnesses, the official concerned, the special PP has given instruction on the basis of which this additional affidavit is prepared. Mr.
PP Medhi, Lordship.
As prayed for by Mr. PP Medhi, learned counsel for the petitioner, lists this matter after
1 week.
After 1 week to enable the petitioner file reply to the additional affidavit filed by the respondent number 2.
my lord.
I'm obliged.
May please also.
Yes.
No affidavit has been filed by the.
Yes, 23.
Lordship, in this matter, my lord, we are awaiting our instructions.
As prayed for by Mr. A. Fukan Leonard, Standing Counsel JD, list this matter after
My lord, 2 weeks, my lord.
2 weeks to enable the said respondent file return in the matter.
So item number 20 is also
Same matter, my lord.
All right.
20 minutes. Deeply obliged.
Depositing of revolver and arms license.
No, Lordship. Item number 19 for promotion.
19?
19.
19.
Lordship.
18 or 20 asila. Promotion. Yes. Affidavit?
Lordship, I have to take instruction. 2 weeks time may be granted, Lordship. 2 weeks time may be granted,
A
Lordship.
year has passed, but the petitioner is also retired.
On January 24, you had taken 2 weeks time. Notice was issued on September 2023. How much more time?
2 weeks, Lordship.
MS?
Z Bora.
As prayed for by MSG Bora.
Lordship.
Learned
Standing Counsel, Agriculture
Standing
Department.
Counsel, Agriculture Department, Assam, list this matter after 2 weeks on a date to be fixed by the registry to enable the said respondent file return in the matter.
Hello.
Right.
21.
Yeah. Mr. Fukan,
Yes,
revolver.
yes, it's a .38.
You are challenging the order by which your revolver is directed to be deposited.
No,
Then
the license was granted. I applied after my father's death. The license has been renewed since 1974. It was an all India license that was granted. Subsequently, after 2004,
Mr. Fukan, this is
the order which has been included is at page 52.
No, I think this the petitioner is that Billworth list before another bench not done.
Great.
Instruction of our time. May I please, Lordship? Kindly give some time for the instruction, Lordship. Kindly grant me some time to receive an instruction,
Instructions.
Lordship.
All right. How much time?
Lordship, 4 weeks, Lordship.
4 weeks.
Lordship.
As prayed for by MS.
P. Rabha on behalf of Mrs. A.
MS.
P. Rabha.
P. Rabha, Learned Counsel, appearing on behalf of
Mrs. A. Gayan, Lordship.
Mrs. MS A. Gayan, Learned.
CGC, Lordship.
CGC list this matter after 2 weeks to enable the respondent file return in the matter.
May I please show Lordship? Lordship, the fact of the case was that I was serving as a supervisor to Balaji Construction Private Limited. My grievance was that I was not receiving the certificate. I was working in the entity. So on the last occasion, respondent treated 6 times to file counter affidavit, and I received the counter affidavit. Lordship, I want to point out the para number 7 on affidavit in opposition, Lordship.
It seems that R2, who is appearing for R3?
My lord, I am appearing for respondent number 3.
3. You had sought earlier time for filing
We have already
counter affidavit?
Yes.
Have you filed?
We have filed.
When did you file?
3 of October.
I don't think that is on record, because what is on record is only the affidavit of respondent number 2, government. You have received that
Yes,
affidavit?
Lordship, I have received.
It is not on record. মৃগাংক এবাৰ চাই লোৱা, ইয়াত মইতো দেখা নাই। R3 R2 খন আছে।
3rd of October.
ইন্ডেক্সত কিয় দিয়া নাই? Yes, you want to show something from here.
Lordship, I have no objection. They have admitted that they will issue the certificate to me.
Paragraph?
Paragraph 7, Lordship. On the last line, Lordship. However, the respondent number 3 can only issue a working certificate to the petitioner required by her. That much only I need. That certificate only I need, Lordship.
If required by her. So they are agreeable to issue.
Yes, Lordship.
Where is your prayer? Mr. Dhar, have you seen this affidavit?
My lord, yes, I have done from my lord. My lord, it's a dispute between my lord, employer and employer. It's a private
No,
entity.
now it appears that the prayer was directing the respondent to issue Aadhaar operator supervisor certificate to the petitioner.
Yes.
This is the prayer.
Yes.
In the affidavit filed by R3,
Yes,
that is the employer.
employer, my lord.
They are saying in para 7
Para 7, my
that they can only issue a working experience certificate
Working
if required by her. Now it is submitted that the petitioner is satisfied with this.
satisfied, my lord, dispose it.
Then I can dispose it of.
My lord.
You issue it
Yes, my lord.
within 1 month.
1 month, my lord.
Within the parameter of law, they will issue certificate.
Heard MS
A. Pine.
A. Payang, Learned Counsel for the petitioner. Stop. Also heard Mr.
R. Sarkar.
Mr. R. Sarkar, Learned Counsel, appearing for respondent number 3, and Mr. R. Dhar, Learned Additional Senior Government Counsel, appearing for the state respondent. Stop. By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking issuance of Aadhaar operator stroke supervisor certificate. Stop. The case of the petitioner is that the petitioner was appointed as Aadhaar operator stroke supervisor on 4/10/2018 at Messrs. Balaji Construction Private Limited, which was the service provider to the General Administrative Department of Government of Assam in Kamrup within bracket M for the project Aadhaar enrollment under quotes, Aadhaar enrollment under Unique Identification Authority of India. The registration, it is the further case of the petitioner that the registration number of the petitioner was Aadhaar ID KM SBC 389262. Station ID is 83005, 83006, 27819, Kamrup EA code 2783. It is the further case of the petitioner that for last 1 year and more, the petitioner has been approaching all the three authorities for the certificate of her work, but they have taken no steps to issue the certificate. Accordingly, this writ petition has been filed. Stop. It appears, and I heard the parties and perused, it appears that an affidavit in opposition has been filed by respondent number 3 within bracket the HR manager, Messrs. Balaji Construction, wherein in paragraph 7 it has been categorically averred that the respondent number 3 can issue a working stroke experience certificate to the petitioner if the same is required by her. Paragraph 7 of the aforesaid affidavit in opposition is reproduced hereunder for ready reference. A to A, page 52. MS so-and-so learned counsel appearing for the petitioner submits that the petitioner requires the aforesaid working experience certificate, and in view of the said endorsement made by the respondent number 3 in the aforesaid affidavit in opposition, this writ petition can be disposed of by directing the said respondent to issue the said working stroke experience certificate. Stop. Mr.
R. Sarkar.
Mr. Swens R. Sarkar, learned counsel for respondent number 3, similarly submits that this writ petition can be disposed of in view of the paragraph 7 of the aforesaid affidavit in opposition. Stop. That being so, this court is of the considered view that this writ petition in the interest of justice can be disposed of with the direction to the respondent number 3 to issue the requisite working stroke experience certificate to the petitioner in accordance with law within a period of 1 month from the date of receipt of the certified copy of the order. Accordingly, the writ petition stands disposed of.
Did we apply?
Much okay.
26.
May it please your worship. Respondent number 4 has filed affidavit yesterday.
Yesterday?
Yes, sir. We will file. Have to file 3 weeks time may be given.
Mr. Mohanto.
Yes, sir.
As prayed for by Mr. H.K. Mohanto, learned counsel for the petitioner, lists this matter after 3 weeks to enable the petitioner to file rejoinder to the counter affidavit filed by the respondent number
4. Respondent number 4.
Respondent number 4, yesterday. So and so.
Much obliged.
Just 1 second. A affidavit content here. Let registry verify and play. However, it appears this had affidavit filed on yesterday dated diva is not on record. Let registry verify and place the same on record.
27.
Compassionate appointment.
Yes, Your Lordship. Lordship,
Your Lordship will find at page number 59 of
I
the
think
relevant
this
para of the
court's
judgment.
order was very clear on 23 September 24. Mr. Thor.
My lord.
Affidavit not filed.
My lord, affidavit not filed. Otherwise,
Who died?
Lordship.
Who died?
Lordship, father of the petitioner died
Father,
in the year
when?
2014.
When?
2014.
17/11/2014. 17/11/2014. Your Lordship will find the death certificate.
17/11/2014.
Yes, Your Lordship. Page number 21.
And when did you file your application?
Application file on 9th, Lordship, 5/12/2014.
5/12/14. After
Yes.
1 year.
No,
Oh,
Lordship.
no, after 1 month.
After 1 month.
Application.
Yes, Your
And
Lordship.
after that, what happened?
Lordship, after that DLC has considered the case of the
DLC?
petitioner, Your Lordship will find at page
When?
number 34.
No, wait, date. Give me the dates first.
DLC 15 to 2016.
15 to 16.
25 to 2016.
25 to 16 DLC.
Yes, Your Lordship.
And then
SLC has subsequently considered 18/1/2020.
SLC considered.
Considered
Allowed.
and no, not considered. Lordship rejected the claim of the
Then say
petitioner.
rejected.
Yes, Your Lordship.
SLC rejected on
18/1/2020.
18/1/2020.
20. Yes, Your
And you
Lordship.
filed this writ petition when?
Thereafter, Lordship, this
When
is
did
the
you
second.
file the writ petition? Give
No,
me
no,
the
Lordship.
dates first.
24.
No, Lordship, this is the second round of litigation.
First, give me after you are giving me the dates, Mr. Counsel. Why are you getting so anxious?
Yes.
After the rejection of SLC, when did you file the writ petition?
In the year 2020.
20.
Yes, Your Lordship.
Which is that writ petition?
Your Lordship will find at page number 9 the order of the Honorable Court. Your Lordship will find page number 9.
WPC?
Sorry, page number 52, Annexer 9.
WPC?
WPC number 1853/2020.
1853
3
of
2020.
20.
Yes, Your Lordship.
Page 52.
Yes, Your Lordship.
Yes, operating part.
Your Lordship will find at page number 58. May I read, Lordship?
Yes, please.
Paragraph 9. In terms of the said office memorandum, although the reservation on account of compassionate appointment was limited to 5% of the vacancies occurring in a year, but it
No,
was
not that is part of the quoted.
quoted.
Come to paragraph 4.
Lordship,
Page
Come to
59. In view.
59, paragraph 4. In that view of the fact.
in view of the in that view of the fact, similar issues have been raised in the present writ petition, and as the councils are in agreement that the judgment of the coordinate bench passed on 7/12/2022 in WBC number 1914/2020 so and so will cover the issue raised in the present writ petition. The present writ petition disposed of in the
So a fresh consideration by SLC.
Yes, Your Lordship.
Now, when was this? When did the SLC?
SLC subsequently
6/12/23.
6/12/23.
Page
62. 12/23. Page?
Page 62.
62.
Operative parties, Lordship, page 63.
And when did you file the present writ petition?
Present writ petition, Lordship, immediately after rejection 2024.
Date.
Lordship. Date 23 February 2024.
23
February.
23 to 24 writ.
Yes, Your Lordship.
Second writ.
Yes, Your Lordship.
What is the ground of rejection? Page 62.
Yes, Your Lordship. Page 63. May I read, Lordship? Third para. The committee therefore truly examined the Gov Office Memorandum so and so dated 2/3/2009 and observed the following from clause 2 of the OM. The 5% of the vacancy in class 3 and class 4 post occurring in a year must be reserved for appointment on compassionate ground. The ceiling of 5% is direct recruitment vacancy for making compassionate appointment should not be exceed. Yeah, Your Lordship will find the observation that was made in the case of Lordship Kamal Krishna Talukdar case, which was relied in the judgment, Lordship. Your Lordship will find at page number 59 the operative portion of the judgment, page number 58. And that only that ground the case of the petitioner has been recommended by the DLC, Lordship. It is very
One
much
second,
apparent
let
in
me
the
just understand this.
Lordship.
Let me just understand
Yes,
this clause. So there is only 5% vacancy.
That restriction is not applicable.
Huh?
That restriction is not applicable.
From where are you saying?
Lordship, your Lordship.
Because the SLC rejected because of want of vacancy, correct?
Yes, yes, your Lordship.
Is it correct, Mr. Dhar?
Yes, ma'am.
Yes.
Want the vacancy.
Where do you want me to go?
Your Lordship will find the operative portion of the office memorandum. The state government has.
1 second, please.
Lordship, the
Yes.
case of the Kamal Krishna Talukdar has been considered and he has been already appointed in the light of this judgment and direction passed by this honorable court. And your Lordship will find the operative part of the office memorandum that is in
No,
paragraph.
but before we go to all this, you said there is some decision of this court saying that this is not applicable.
My lord, it's a very simple case, my lord. The petitioner's father died in 2014. In between, my lord, twice it was considered, once initially by the DLC, then SLC rejected, again by the direction of the honorable court, again it was considered and rejected. In between, 10 years has passed. He was able to, my lord, sustain himself from the whatever pecuniary, my lord, loss in this period, my lord. So, my lord, Devabrata Tiwari comes in, my lord. Following Devabrata Tiwari's judgment, my lord, this honorable court has at least passed, my lord, numerous judgments. I have so many.
1 second. Yeah.
My lord, honorable Supreme Court is very clear on this. If a person has sustained compensation, the Supreme Court has held that, my lord, compensation upon
1 second.
immediacy.
1 second. 1 second.
My lord.
It appears that there is one petitioner in person, but however he's standing, I would request one of the junior advocate to lend him a chair.
I'm sorry.
Yes.
My lord. So, my lord, so basically, my lord, this is a squarely covered case by the Tiwari, my lord. That immediacy is lost.
See, Mr. Pujari, I understand Devabrata Tiwari.
Yes,
in fact, there are a couple of decisions that this court has also authored by relying Devabrata Tiwari, correct? But now, it appears that there are certain situations where before Devabrata Tiwari had come, the petitioner had already taken some order from this court, whereby the petitioner has taken order in the nature of reconsideration, correct?
We have reconsidered.
It appears. Now, therefore, instead of going to Devabrata theory, let us, because this court cannot now examine the policy, that decision that you have taken,
lord,
but the only how you have
Tiwari
taken
will
it.
override all the judgments, my lord. That's the Supreme Court judgment, my lord. Obviously, my lord, Supreme Court judgment will, my lord, it becomes the law of the country. So, my lord, Supreme Court judgment will prevail over all the orders.
Here, your ground of rejection is want of vacancy.
Want of vacancy.
So, that is on the basis of some office memorandum.
Office memorandum.
Now, is there any decision of this court by which it has been said that even if there is no vacancy, you have to give it?
No, my lord.
Because compassionate appointment as a right cannot
There
be.
is no, it's not a matter of right.
It is not as a matter of right.
Matter of right.
Isn't it?
Yes, my lord.
So I am trying to understand it in this manner. Instead of going to Devabrata Tiwari.
Yes, your lord.
You show me, because you have already reconsidered. That reconsideration need not be positive. It can be a negative reconsideration, but that doesn't mean that this court will interfere unless and until, of course, it appears that your reconsideration is bad in law.
Your Lordship may kindly come to page number 59.
My lord, I have one judgment here of this honorable court, my lord. It's a single bench, but here both the things dealt with. That 5% thing, and my lord, then the Devabrata Tiwari.
Lordship, this is the judgment that is decided on the basis of the Lordship office memorandum which has been passed by the state government in the year 2015. But
Mr. Counsel, the problem is you both know all the decisions. This court doesn't know. Let me just have a look at this decisions. This is in the case of Gunawati Fukan Hazarika. Yes, paragraph.
My lord will this finding of the court, my lord, para 1, 2, 3, 4, my lord.
Yes.
There, my lord will find that 5%.
Yes, yes.
It's been
Paragraph
kept.
4.
Yes, my lord.
It is the case of the petitioner that in the DLC meeting held on so the name of the petitioner was recommended. However, SLC rejected the case of the petitioner on of availability of vacancy under the 5% quota.
delay in filing the writ petition.
It beleg issue.
Silence, yes.
The object is considered in para 10.
Para 10 from 10, 11, my lord, it starts, my lord. That is what I was into, my lord. Here it is 8 years, here it is now 11 years. এগুলো সব ওভাররাইট করে না সব ওভাররাইট করে
Yes, what were you saying?
Lordship, this judgment is not applicable in this present case. The issue involved in this writ petition earlier was that, Lordship, whether the office memorandum 2015 will be applicable in the case of present petitioner, or it will be applicable as per 2009 office memorandum. 2009 office memorandum, it is clearly says that, Lordship, rule of 5% restriction on compassionate appointment, that is not applicable. And so far the
where it says not applicable?
Lordship,
which from where are you saying
Your
that
Lordship,
2009 OM is not applicable?
Your Lordship will find in the office memorandum.
Where? Where is
Page
it?
number 58. Operative part is there, Lordship.
58. 58 is the part of the order.
Yes, Your Lord, that operative office memorandum is enclosed, and Your Lordship will also find in the recommendation that has been made by the DLC.
Mr. Counsel, one by one. This court is asking you a pointed query. Why can't you just simply answer? Where is that? From where are you saying it is not applicable? Please show me that.
Your Lordship will find at page number 58.
Yes. Now where 58? You let me first have a
State
look at
government,
it.
third para, Lordship. State government had adopted a scheme. State government had adopted a scheme, and the last 3 line, Your Lordship will find the restriction will, however, not apply where only 1 vacancy is to be filled up in a year.
The
Thus,
restriction will, however, not apply where 1 vacancy is to be filled up in a year.
Thus, the department can appoint 1 person on compassionate
Here it
ground
is
against 5%.
here it is
quota.
1 person.
Yes, Your Lordship.
From where are you showing?
Your Lordship will find at page number District Selection Committee. Your Lordship will find at page number 34. Starts from page number 34.
Yes.
An operative part.
Yes. Yes.
Page number 37. One post. Number of vacancies. But page number 38, Lordship.
Page number
38. Applied within 1 year. SS first applied for the post of grade 4. The meeting discussed the proposal and recommended for the post of grade 4 against single vacant post.
That is the problem of my lord. That is, unless there is 20 posts, we cannot carve out 1. That is the
rule only in the case of 2015.
Mr. Dhar, is this a case where it was 1 post?
My lord, you'll see here, he was recommended by DLC placing a single vacant post. Whereas, my lord, when it comes to SLC, my lord, the rule is, my lord, there has to be, my lord, 20 posts. Out of 20 posts, we carve out one 5% quota.
From where are you saying that, Mr. Dhar? From where are you saying that?
5%, my lord.
No, because I'm trying to understand this. You see, Mr. Dhar, simply by going to Debabrata Tiwari will not do, because there is an order from this court also, right?
My lord.
In view of that, I'm trying to see both. Now, it appears that in that office memorandum, relying on which the SLC had rejected the case of the petitioner, there is also a provision which says this office memorandum shall not be applicable, where only one vacancy is to be filled in a year. Now, has this been proved? Have you denied this? If you have denied it, just show me from where you have denied. In your affidavit, if you have said that there were
My
more
lord,
vacancies,
the thing is that we haven't filed affidavit.
then you file it. It cannot be disposed of like this. The affidavit is essential. Last chance for 1 week is given. There was already a positive direction, so I will say failing which the officer concerned will be personally present.
1 week will be difficult. My lord.
All right, I'll give you 2 weeks, but
My lord.
failing which personal appearance.
My lord, what happened? This Borpeta, there was an election, so that's why, my lord, this all the officers
By
are very
order
busy.
dated 23/9/2024, this court, while allowing the respondent time to file their return, clarified that failing filing return by the next date of listing, the writ petition shall be proceeded in accordance with law. Stop. Today, when the matter was called, it appears, despite of a positive direction for filing return, no return has been filed. Accordingly, the matter was taken up for hearing. However, it appears that due to want of affidavit, the hearing could not be proceeded. Accordingly, a last chance of 2 weeks is granted to the
3 weeks, my lord.
a last chance of 3 weeks. Mr. Nath is smiling from the back, Mr. Dhar. Last chance of 3 weeks is granted to the respondents to file their return in the matter. However, it is made clear that in the event the affidavit is not filed by the next date of listing, the officers concerned shall either be present in the court at the time of the matter is taken up, either through video conferencing mode or personally. Stop. List on such and such date.
Highly obliged.
Please, Lordship. Lordship, in this case, Lordship, we have implemented a new respondent, Lordship. Number 6, Lordship.
Newly implemented respondent.
Lordship, Lordship. So notice may go, Lordship.
Notice has to go.
Yes, Lordship.
Notice not issued.
Yes, Lordship.
Not issued.
Not issued, Lordship. Upon the respondent number 6, Lordship.
All right.
My lord,
Let notice be issued to the newly implemented respondent number 3.
Six.
Respondent number 6 through registered post AD.
No, my lord, I being the CGC, I can take
be issued. Stop. Mr.
AK Doctor.
AK Datta, learned Standing Council CGC, accepts notice on behalf of newly implemented respondent number 6. Extra copies within the
course of the
day.
4 weeks
List
time.
after
4 weeks time, maybe.
4 weeks on a date to be fixed by the registry.
29.
Affidavits not filed, Mr. Nath?
We have filed on Monday. Possibly it is not.
It has not. Have you received?
Yes, Lordship.
Mr. D. Nath, learned senior, learned standing council, APDCL. APGCL submits that the return has been submitted on
Monday.
On Monday date to date, on such and such date. Stop. However, the same is not available on record. Let registry place and verify and place the same on record. MS
D. Devi.
D. Devi, learned counsel appearing for the petitioner, submits that a copy of the same has been received by her office, have been furnished to her office. List when?
Next week.
List next week on a date to be fixed by the registrar.
May I please, Your Lordship? Inspection was called for in this case.
Yes.
Page 49.
Instruction, Ms. Devi.
Lordship, parawise copy, parawise comment received, Lordship,
Received?
yesterday. Yes,
So you
Lordship.
file your affidavit?
Yes, Lordship.
MSR Devi, learned CGC, submits that the parawise comments have been received by her office in this matter and accordingly seeks accommodation to file the same by way of an affidavit. Prayer is allowed. List after 3 weeks on a date to be fixed by the registrar.
2 weeks, my lord. My respectful prayer will be for
All
2
right,
weeks.
2 weeks.
I am deeply obliged.
My lord, this matter pertains to non-payment of retirement benefits.
Yes, affidavit.
My
Mr.
lord,
Bor, you are appearing.
I am appearing for respondent number 4 and 5.
Mr. Bor Pujari, Finance.
I need some instructions to be received.
You have received instruction?
No, no, my lord.
So you both want to file your affidavit?
Yes.
We are just a formal party out here.
You're not filing anything? As prayed for by Mr. A. Dhar, learned counsel, appearing for respondent
4 and 5.
4 and 5. List this matter after
2 weeks, my lord.
2 weeks to enable the said respondent file written in the matter.
And date may be fixed, my lord.
All right, next.
Item 33.
Obliged.
May I please, Your Lordship? Lordship, as per order dated 25/9/2024 of this honorable court, respondent number 224 were supposed to file their affidavit.
Return. Yes. What happened? Return. Mr. J.K. Goswami had appeared state. Mr. Nath, on the last occasion, Mr. J.K. Goswami had taken time on behalf of the state respondent. Is the file available with you?
No, kindly take it out after some time.
Sorry?
After 5 minutes.
Okay. Just find out what has happened. Wait. I shall resume in 5 minutes. Affidavits not filed. Today is the returnable date.
Yes.
Yes. Who's appearing? Ms. Devi, you're appearing?
Lordship, I'm appearing for item number 1, for respondent number 1 and 2, Lord.
Item number 1 or respondent number 1?
Respondent number 1 and 2, Lord.
How much time, Ms. Devi?
4 weeks time maybe.
As prayed for by MSK Devi, then at CGC, list this matter after 4 weeks to enable the respondent file written in the matter.
Much obliged.
Obliged.
35.
My lord, we are appearing on behalf of the Punjab National Bank.
Today is the returnable date.
My lord, we require to file our affidavit in
Today it has
opposition.
come first time after notice.
Yes, sir.
So let the respondent file their return, file their affidavits. How much time?
4 weeks time.
4 weeks time. What is the matter? You need 4 weeks.
My lord, the time will require because the instruction will come from head
What is the
office.
matter?
My lord, it's a matter where the challenge is the promotion. And that
3
was
weeks, Mr. Doctor.
3 weeks. All right.
Lordship, already 4 weeks time was given for submitting this.
No, that is the, you see, at the time of issuing notice, that is how it is done. Today it has come first time after the issuance of notice. So, as prayed for, heard petitioner in person, I. Shri Debashish Roy. Also heard Mr. S. Dotto, learned senior counsel, assisted by K. Bora, MSK Bora, learned counsel for the respondent bank. Mr. So-and-so seeks 3 weeks time to file return in the matter. Prayer is allowed. List after 3 weeks on a date to be fixed by the registrar.
Obliged.
Give a date because you're appearing in person.
Yes, sir. Lordship.
16 is approved.
Highly obliged.
Item 36.
Please, Your Lordship. I want some time to file affidavit in opposition.
Heard Mr. A.K. Sahewala, learned counsel for the petitioner. Also heard Mr. A.K.
Okay,
Agarwal,
for respondent number
learned
3 and
counsel appearing for respondent numbers 3 and 4. And Mr. S.K. Roy, learned
1 and 2.
counsel appearing for respondent number 1 and 2. As prayed for, you both are filing?
Yes.
As prayed for by Mr. A.K. Agarwal as well as Mr. S.K. Roy, learned counsel for the respondents. list this matter after 3 weeks to enable the said respondents file written in the matter.
Well, interim order passed earlier.
Interim order, if any, shall continue till the next date of listing.
Similar matter.
SS Roy. 37 similar?
Similar.
Same.
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 Deeply.
Supplementary admission 52.
This BTC. It was made absolutely clear that if Mr. B. Chaudhary continues being indisposed, alternative arrangements to be made. What happened, BTC? Mr. Nutt, can you send a message for the BTC lawyers? Mr. Borpachari, you're there? Okay. Wait.
53.
Yes, Mr. Das.
That the matter was heard by your lordship.
3 matters.
Regarding about the construction and routine maintenance, where they were deduct. I found one more point. In addition to the judgment.
Where is
of-
PWD?
I think the last time also. I have a Buddha material.
It's very difficult to proceed when the
Yes, I know
respondent
that.
and it is not nowadays. There are a battery of panel
They have
advocates
got
in all
lot of-
departments.
yes, lot of lawyers are.
They should be available.
I also find it difficult that without here other side, it is not proper. Without
It
other
is
side.
no, because if some effective order has to be
No,
given,
you have to hear
then
it. Other side, yes.
hey, wait for some time, Mr. Das. You can ask your junior also to Mr. Nath. Anyone from PWD is here?
But Mr. B. Gogoi, he will appear in this case. He's on his way. He's coming.
All
He
right.
will appear.
You wait for some time.
38 orders.
Your Lordship,
Yes.
Lordship, here in this matter, the Guwahati High Court was supposed to file affidavit.
Huh?
The Guwahati High Court respondent was supposed to file affidavit, my lord.
Where are they?
Oh, no.
38.
38, my lord. Because, my lord, here the case is that he was appointed as attached fiancé on 2005.
But no affidavit.
No affidavit till date.
Who is appearing? Last time.
Last time was
Your name?
S.G. Borua.
Heard MS S.G. Borwa, learned counsel for the petitioner. None appears for the respondent on call. It appears that the Guwahati High. All right, I'll list it next week.
No.
List again next week on a date to be fixed by the registry.
My lord, with due respect, my lord, can it be after, because from 26
Yes,
till
yes.
from 26 till 1st, I won't leave, my lord.
All
So if
right,
it
when
comes
do you want it?
After 2 weeks.
After 2
Anyway,
weeks?
after 2 weeks. Must oblige,
Any
my lord.
specific date?
My lord, thereafter.
After 2 weeks on a date to be fixed by the registry. All right.
Must oblige, my lord.
39%.
Mr. Dekar, it appears this matter was not listed as I have directed.
Yes.
Is someone appearing in this matter today?
Yes, my lord. Respondent number 6.
So has she engaged someone?
Yes.
You will be representing her.
Yes.
Please have a seat, ma'am. Mr. Deori, please give her a chair. Please sit down. You see, this court had no option but to direct personal appearance, because it appeared that the brief was taken from the earlier engaged counsel, and thereafter no re-engaged meant was done. So this court had no other option but to seek. Now that you are appearing, this court will give you time. You file your response in the matter, because I'm sure you have already gone through the order of 29/2024.
Yes.
Prima facie looks like the
Yes.
order of this court has not been
Yes.
complied.
Yes.
So,
My lord, the thing is that, my lord, the main petition, writ petition was disposed of on mainly on 2 grounds, my lord. The reinstatement, that could not be done because the petitioner had already retired, my lord. And regarding payment of arrears salary, my lord, that was not done because of some financial difficulties, my lord. They do not have the requisite funds, my lord. Now they have taken a resolution in the board, my lord, to pay rupees 10,000 per month, my lord. So if they are agreeable, my lord, then we can do something. Because
Mr. Das,
yes,
please be
Yes.
mindful that first of all, this is not an executing court.
yes, yes, my lord, I understand that. My lord.
Correct.
My lord.
So please don't convert contempt proceedings into an executing proceeding.
My lord.
That should not be the second thing is that in case there was some difficulty, there were some fund issues,
My lord.
there are remedies available.
My
It is not understood why these remedies are not being availed in such matters, and instead matters are being
My lord.
lingered around. That is not the
My lord.
correct approach, right? You convey
My
the
lord.
message of this court to your client and file your response,
My lord.
because I find paragraph, you must have seen the order of this court, which is reflected in the order itself. There was a positive direction,
Yes,
correct?
last opportunity was given.
Yes.
Yes.
And that resolution 16/8/2023, it simply says, since the Kanpur Municipal Board is a very small board and the amount of collection of revenue is also meager, so the board is not in a position to pay the back wages. If government releases the fund and the back wages entitled to the petitioner, the member shall have no objection. These are not,
My lord.
Mr.
Wait,
Deka?
please,
Yes, please.
Lordship, the respondent number 6, they have already filed their affidavit in opposition, and Lordship has noted everything in last order. Now there is a order of the court. Now they are to comply, because today respondent number 6 is before this court, but today is also she is not complying or disobeying the order, continuing.
Mr. Deka, since she has appeared today, so I'm posting it after 2 weeks. In the meantime, let Mr. Das, perhaps something might come, because it appears that they are willing to make the payment, but they are having fund problem. Let them sort it out. Let us see what happens after 2 weeks.
Yes, that is there, but
All
my
right.
instruction is that even till today they have not calculated how much the petitioner is
Mr.
entitled.
Das, should I say that you would make an effort
Yes,
to come? Huh?
Yes.
In terms of the direction dated 29/2024, MS Dharitri Borua, chairperson of Kanpur Municipal Board, Kanpur, Nagaon, is personally present in court today. It appears that who is arrayed as R6 huh? It appears that Mr. S. Das, learned counsel, has been engaged to represent said respondent number 6. Stop. Mr. Das further submits that an opportunity be given so as to enable the respondent settle the matter. Though the powers of this court is not of an executing court, however, making an exceptional last opportunity is given to the respondent. List again after 2 weeks, 3 weeks corridor, and on such and such.
Lordship, settle the matter in terms of the order, judgment, Lordship. Otherwise, they will
Settle the
negotiate.
matter in terms of the judgment and order dated.
Judgment and order dated 1/4. Sorry.
1.
One 2009.
1/3. Mr. Deka, you also inform your client if they are willing to have an amicable settlement and an out of court is required. Both parties can sit and sort it out. Whatever can be done, because your client is also interested in the area salary at the end of the day. So what is required is that payment.
Salary.
Anyway, you try and
regarding outstanding salary, my information is that he already calculated through a private CA.
So you can inform Mr. Das. Mr. Das, you can have a word with Mr. Deka. I'm sure with both of your good office, the matter can be settled.
Highly obliged, madam.
Obliged.
Personal appearance to record discharge.
Lordship, the last instruction that I submitted before your Lordship has seen that there was no fund for PHE department, in which department the petitioner has made supply. Lordship, now the authorities
Mr.
are.
Chaudhary, I have forgotten. Your last instruction, which is that 1811-24 order,
Yes, 12th November, Lordship, the
indicates
instruction
that
was
the
there.
claim of the petitioner shall be placed in the next financial year in view of paucity of fund in the current. Yes,
Lordship,
you have the time frame now.
Yeah, Lordship, I'm submitting that. Lordship, they are now in the process of making allocation of fund for the PHE department, where there are other outstanding liabilities are also there, and the petitioner's name comes at serial number 36 in terms with Tamsir Ali. As soon as the fund is made available, Lordship, accordingly as per the Secretariat, Lordship, it will be paid. Lordship, my humble prayer, Lordship may take it up after 1 month. In the meantime, whatever development takes place, I will submit it in a form of affidavit.
Something is going on. Something is better than nothing.
Yes, Lordship, he will get something, Lordship, at this moment, whatever information I have got.
All right. Mr. B. Chaudhary, Learned Stelling Council, BTC, submits the latest instruction received from the Secretary, BTC, Kokrajhar, by letter dated 12/11/2024.
Lordship has already quoted that.
So this
that
is the
letter.
last one.
Yes.
On 18.
The paucity of fund, Lordship. That's a verbal instruction, Lordship. In the meantime, I will bring it on record.
Why, according to you, the matter is under process.
Under process of allocation of fund to the department, so that
Mr. So-and-so, Learned so-and-so submits that as per his latest verbal instruction, the matter is under process for allocation
of fund to the PHE department.
To the PHE department.
For disbursing of outstanding.
In order to enable release of the contractual bill
petitioner and other contractors.
bill due to the petitioner and other similarly situated persons. Stop. In view of the above, list this matter
Lordship,
after 3 weeks.
Yes, Lordship.
On a date to be fixed by the registry. এখন ঘুরাই দিব ভাই। Apply জ্বালাচ্ছি।
If I may, Lordship. Lordship, the engaged counsel in this particular matter has just recently been appointed as a honorary director to the respondent to the bank. Lordship.
You want to make alternative arrangement? You
Yes,
want
Lordship.
accommodation for that?
Yes, Lordship.
It is submitted that the engaged counsel for the for the petitioner due has due to the recent occupation, due to recent engagement in
As an honorary director, Lordship.
as an honorary director
Yes, Lordship, to the bank.
in a bank cannot appear in the matter.
Yes, Lordship.
And accordingly, accommodation is sought for making alternative arrangement in the matter. Prayer is allowed. List after 3 weeks on a date to be fixed by the registry. You make your alternative arrangements by then.
Yes, Lordship. Much obliged.
41.
Item 41.
Yes.
Service against.
Service is awaiting.
Service is against the newly implemented petition. Respond number 3 is complete. 3 and 4.
Huh?
3 and
Who
4
is
is.
appearing for the newly implemented respondent number 3 and 4?
I will file my affidavit.
You are appearing, Mr. Bora?
Affidavit.
Mr. S. Bora, Learned Counsel, enters appearance on behalf of the newly implemented respondent numbers 3 and 4
No,
and
3
6.
only 3, my lord.
3 and 6.
2 weeks time to file my
2 weeks time to file
the affidavit.
file
And
return in the matter. Prayer is not opposed. List after 3 weeks on a
No,
date
sir.
to be fixed by the registry. You want something? Please record the
In the other case, my lord, service is not complete.
Parties are similar.
What is the same? But service
Which
is not
one? Which one?
42.
Item
42.
42.
42.
Against respond number, I check the record.
But
Against
you can appear.
I can appear. I can appear.
So I'll say that you have
Lordship.
received instructions to appear
Same thing, my lord, but
in
Service.
item 42, that Mr. S. Bora has submits that he has instructions to appear on behalf of the newly impleted respondent number 3 and accordingly seeks accommodation to file power in the matter. Prayer is allowed. List after so and so. Okay,
Obligement.
43.
Here, Lordship, pursuant to order dated 21/10/24.
You wanted to file a rejoinder. Have you filed?
No, Lordship, I had filed one IA for impleadment of the headmaster, respond number 6. That IA has been allowed on 21/10/2024.
IA allowed?
IA allowed for impleadment. Now, Lordship, I want to take steps on the newly impleaded respondent.
Notice has not been issued to the newly impleaded.
No.
Have you filed your amended cost title?
Yes.
You have. Newly impleaded respondent numbers?
Number 6, Lordship.
Number 6?
Only 1%.
What about 7?
7, sorry, 7.
Number 7?
7.
Let a notice be issued to the newly impleaded respondent number 7. Steps by registered post AD within a period of 3 days from today. List after 2 weeks on a date to be fixed by the registrar.
Obliged.
Time being 33.
Make this your lordship. Lordship, in this case, we are required to file our affidavit, lordship, but due to some this difficulty, lordship, we could not be filed within time, lordship. So I may pay for some accommodation for lordship for 1
How
day.
much?
2 weeks time may be granted to us, lordship.
Mr. CKS Borwa, Learned Counsel for respondent. You are asking him.
No, the thing is that lordship, the main problem is that our file got misplaced.
Find out.
Lordship, 224, lordship.
Respondent number 224 submits that further time, 6 further 2 weeks time to file the necessary return in the matter. Prayer is allowed. List after 2 weeks and a date to be fixed by the registrar.
Obliged, Lordship.
44.
May I please, your lordship?
Yes.
Lordship, in this matter, right, the office number 12/11.
Mr. Hajorika had appeared on the yes.
You see, I am paying for respondent number 1 and 2, lordship.
1 and 2.
Amguri Municipal Board is required to be.
What about 4?
They have served notice by registered ID, my lord. And this is the Dusty service.
4 is Amguri board also.
Yes, sir.
So you will appear for?
No, 1 and 2.
1 and 2. What about the Amguri Municipal Board 3 and 4?
They have received notice by registered ID, my lord.
They have received?
Yes, they have received. At 12,
you will file your affidavit?
So we'll follow it. Yes, we will follow. Our side will follow it.
I think it's still awaiting 3 and 4.
Register for one ID card has been received back.
Where is that?
There is no
Oh, I'm sorry.
12/11/20.
I'm sorry. I stand corrected. What about 4?
4 also, I think.
No, the office note only talks about R3. AD card has been received back in respect of R3. What about 4?
4 was that time on government affidavit was appeared, right? 4 agreed being the government.
No, 4 also you have to take steps. I don't find 4. 4 is the executive officer of the
Yes,
board.
madam. Yes.
That's it.
Office note indicates that service in respect of respondent number 3 is complete. Stop. However, it appears that registered that steps for service in respect of respondent number 4 is yet to be taken. Mr.
H. Rahman.
S. Rahman, learned counsel for the petitioner, requests seeks 2 weeks time to seeks accommodation to take fresh steps in respect of respondent number 4 by way of registered post AD. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry.
Obliged.
45.
Please, Your Lordship. Lordship, the conducting council is suffering from viral fever. This matter may be adjourned for today.
As prayed for on behalf of the petitioner, list this matter after 2 weeks on a date to be fixed by the registry.
Lordship, we have already filed the affidavit. Let this matter come for admission, Lordship.
They might want to file reply. Okay.
46.
Yes.
Please, Your Lordship. This is the
Mr.
second round of
Kalita. Industries.
Lordship. They were supposed to respond number 8, Lordship.
Who is R8?
They were supposed to take steps on respond number 8.
Yes, fresh steps R8. Have you taken?
Lordship, I have to check.
Huh?
I have to check that.
You have to check. What have you been doing? The matter is posted today. In orders, by now you should have checked and informed the court. Have you taken or you have not taken? Because the office note dated 19/11/24 says it appears that a mention has been allowed for listing. But it also says petitioner is ready to take fresh steps. Where is your fresh steps?
My Lordship, some time may be given. I will check and.
This is not the way you take court process for granted. It is at your instant the matter was listed, and it appears you have not even bothered to take the fresh steps as was directed. So you take it
Lordship.
as prayed for by Mr.
K. Jain.
K. Jain, learned counsel for the petitioner, lists this matter after 2 weeks to enable the petitioner to take fresh steps for service of notice upon the respondent number 8 by way of registered post with AD as well as by usual court process through the office of the learned civil judge, junior division, Kamrup M, within 7 days from the date of this order.
Lordship, meanwhile, the Industries and Commerce Department will file their affidavit.
First, you do what is to be done. Do not dictate this court to pass orders. You are not doing your part. You are getting this matter listed, and you don't even know what is the state of the status.
Apologies, Your Lordship.
Appearing to the respond number 5.
Appearance to duty book. B. Sharma for respondent.
5.
And N. Kalita for A. Kalita for standing counsel industries.
1 to 4.
1 to 4.
Obliged.
47.
This IA has been preferred by the Union of India, my lord, for early hearing of this.
Early hearing?
My lord, actually, my lord, this admission stage, my lord. I have earlier, my lord, requested the registry also, but it is not listed because of that, my lord. Department
No,
is.
but if you wanted a listing, you could have make a mention before the appropriate bench, and it would have been listed in admission.
Fact is that, my lord, this is a third round of
Now,
litigation.
unless the matter is admitted, how can I entertain the application for early hearing? Mr. Parashar, please apprise this court.
Actually, my lord, it should be, my lord, in admission column, my lord.
You could have mentioned. I don't think there is any bar in
No,
making
yes.
mention for listing matters in the admission column.
Earlier, once I have given application before the registry, but it was
I'm not,
Yes,
Mr.
yes,
Parashar,
yes.
I'm not talking about the registry.
But,
Huh?
maybe it is not listed so many days, my lord, maybe listed in admission column, my lord. Otherwise, my lord, this is third round of litigation and petitioner is enjoying the interim order since, my lord.
No, that is all
last
okay,
September.
Mr. Parashar. But how can I allow an application for hearing when the matter is yet to be admitted?
And my lord, this application, maybe I am not pressing this
You
application.
withdraw this application and in the main writ petition, I shall admit it. Is the pleadings completed?
Pleadings completed, my lord.
Pleading completed?
My affidavit is not filed. Actually, what has happened, my lord, the petitioner challenged the order passed by the
State
scrutiny
level.
committee, my lord, state level scrutiny committee for SC and ST. So that will be my stand in any way, my lord. And
No,
they are-
but what I am trying to understand is the writ petition ready for hearing?
My lord, I think the central government, my lord, they have filed their affidavit.
Because if it is ready for hearing, then I shall admit and post it for hearing.
Your lordship can
In the
it
month
can
of
be
December
disposed
or
of,
January.
That can be done, my lord. In the meantime, if I let's say
You file in the meantime.
In the meantime, my lord, my prayer is that, my lord, if possible, my lord, it can be disposed of in admission stage itself, my lord, because, my lord,
Mr.
the issue-
Parashar, first of all, you file an application for an early hearing. Then now you are saying admission hearing. You are also not sure
No,
what you
I'm
want.
not pressing, my lord, this, my lord, just
First that I will Mr. K.K. Parashar,
CGC.
learned CGC, appearing for the applicant, seeks withdrawal of the instant application. Stop. In view of the aforesaid endorsement, the application stands dismissed on withdrawal. Upward numbers of DTP. Bhargav. Mridhanko, please take all the names. Yes, now writ petition.
my lord, when a state level scrutiny committee, expert committee has given the opinion that.
One second. You are appearing for CGC.
No. He is for the petitioner.
I'm for the petitioner.
You are for the petitioner. You are for the CGC.
Your lordship.
You, being as a respondent, you want to expedite the hearing.
My lord, because he is, my lord, interim on the basis of interim order, my lord.
Have you filed your affidavit?
Yes.
You are 3 and 4, 5 in the writ petition.
Yes.
2 and 5. Mr. Goswami, you don't want to
I'm
file.
for 6, 7, 8, 9.
You don't want to file.
My lord, if it is fixed for a hearing, my lord, in the meantime, well, I have written, my lord, no instructions come, but our stand will be the same. Scrutiny committee
stand.
Heard Mr.
G.R. Datta on behalf of G.R. Datta.
G.R. Datta, learned counsel, appearing for the writ petitioner. Stop. Also heard Mr. K.K. Parashar, learned CGC, and Mr. B.D. Goswami, learned counsel, appearing for respondent numbers
6, 7, 8,
6, 7, and 8.
8,
Stop.
9, and 9.
8 and 9, huh? Stop. It appears that the respondent Union of India has already filed affidavit in opposition on 4/1/2024. Stop. You don't wish to file a reply?
Your lordship, Mr. S.K. Duri, he is on legs in courtroom number 1. So he instructed me to just.
Are you filing your reply or you're not filing your reply?
I don't have the proper instructions at this moment here.
It is very difficult when you appear before the court and you are not even even if someone asks you to appear, you at least find out what is to be said.
Your lordship, actually, the matter just got called out. I had to rush. I didn't.
That in view of the urgency expressed by Mr. K.K. Parashar, learned CGC, list this matter next week on a date to be fixed by the registry. Stop. For admission hearing.
I'm obliged.
Time being at 14.
I'm sorry, Your Lordship, I was on legs in court number 1.
Yes.
Your Lordship, regarding this particular present status, I've got this because the last order was of 24/7/24. After that, Your Lordship, I inquired and I got this one from the SP and the other one from SP. I'm sorry, Your Lordship, it is in draft paper. Actually, I sent the. One particular letter is from the Superintendent of Police Tezpur.
And that is pension proposal was submitted after obtaining the signature of the petitioner. Yes. On requisite documents. Yes. The question here now, what is to be done? Now the pension proposal has been submitted to the government, the Department of Home. Now who has to submit? No, we have submitted the police department, the superintendent of police. Now I have to get the status report as to whether the Home Department has approved or not the pension proposal. That is the. So you have query. That information. Yes. Mr. D. Bora, Learned State Council, submits that instruction as whether the subject proposal has been forwarded to. Has been approved by the Home and Political Department. Has been approved by the Home and Political Department. Home and Political Department. Government of Assam is awaiting. He accordingly seeks 1 week time accommodation. Prayer is allowed. List this matter after 1 week on a date to be fixed by the registry, on which date Mr. D. Bora, Learned State Council, shall apprise the court as regards the status of approval of the subject pension to the petitioner. But that may be fixed. Date is valid. 28. Obviously.
Time being 53.
Yes, Mr. Gogoi.
I'm sorry, my lord. I was a bit late. 4-1. Let us start, my lord. The affidavit has been exchanged. Affidavits have been exchanged, my lord, both sides.
Mr. Gogoi, sorry, Mr. Das, you had relied on a similar judgment at page 146.
Yes.
Routine maintenance.
Yes, I just point out two things, my lord. That I think that the learner single judge at that relevant time, I was that in that case, if I'm not mistaken. And the learner single judge has said that so far as routine maintenance is concerned, that is separate altogether. That you cannot recover forfeit from the security. Security is under different heads. What I found yesterday after going through, there are one more issue which I just want to place it. If your lordship looks into the writ petition at page 19, please look 19.
Yes.
Your lordship will keep in mind that there are two packages in this case. Package number 29 and package number 33. It is under the PMGSY scheme.
Package number
29. Lordship will see 19. Your lordship will kindly see 4-6 in that 19 package
page
number
19.
19.
Page 19. That is annexure 1.
Annexure 1.
Yes.
See the after 4-5 lines, package number AS 20-29.
AS 2029. Yes.
This is a PMG. This is a one package.
This is one package.
Kindly see the wording, very important. Pursuant to your furnishing the requisite performance security as stipulated in so and so, signing contract for the construction of the work so and so, including so and so, and please note, and routine maintenance of the work for 5 years. We have been instructed to proceed with the executive said work in accordance with the contract document. Right? This now, if you turn to page 20, this is another package, same wording. See column 6.
AS 2033.
33. These are two packages. Now, if you look into page 21, these are the bidding documents. So far as package number 29 is concerned, if you see for the year 2006-2007,
page 21.
Page 21.
Yes. Package is
package
2029.
29.
That is the first package.
First package. Now, Lordship will please go further at page 44. 44. This is package number 33.
Yes.
Please go down below package number.
This is the second package.
Yes, second package.
Yes.
Now, my lord will kindly look into. Now, if you do any construction work, the security amount, that is number one, a performance security one contractor has to deposit. Secondly, that will be kept by them.
And from the running account, running bill, 5% will be deducted from each running bill. Now, where we find how a secure deposit being kept and when it is to be returned to a contractor, please look into page 37. 43.
Yes, security deposit.
See 43.1.
Yes.
The employer shall retain secure deposit of 5% of the amount from each payment due to the contractor until completion of the whole of the construction work. Now, this line your lordship will kindly note
No
down.
security deposit retention
Shall
will be retained from the
retain-
payments for routine maintenance of
No
work.
security deposits retention
clear
shall be
bar.
retained. Yes, I'm sorry.
It's a clear bar.
There is a bar. No secure deposit retention shall be retained from the payment of routine maintenance of the work. So whenever, my lord, that is what I'm saying, routine maintenance is a separate head.
One second, Mr. Dutt.
Yes.
The employer shall retain security deposit of 5% of the amount from each payment due to the contractor until completion of the work, whole of the construction work. No security deposit retention shall be retained from the payment of,
For routine maintenance work. So I think it is very clear on this issue. Now
Subject
see
to
further.
what Mr. Gogoi
No,
said.
I'll just, that's why I am saying 43.2 kindly look into.
43.2, yes.
On satisfactory completion of the whole of the construction work, half the total amount retained as secure deposit is repaid to the contractor. 1/4 of the total amount retained as secure deposit is repaid to the contractor at the end of the second year after completion of the construction work, and balance of the amount retained as security deposit is repaid to the contractor at the end of the third year after completion of the construction work, subject to condition engineer has certified that all the defects notified by engineer to the contractor before the end of period prescribed for repayment has been
Procedure is
corrected.
given.
These
How
are-
to return,
Yes,
how it will be.
My lord,
deducted.
what I understand from this clause, once you complete and there is a completion certificate, then the first year 50% has to be paid. Second year is 1/4 has to be paid, and the last year is 2/3 has to 2/3.
So within 3 years it will
3 years it has to be
it has to be
completed.
paid back.
Yes, and if there is a defect which is found by the employer, then there is a provision on how a notice has to be served. This your lordship will kindly see at page 35, 33. See 35. Page 35, 33.
Yes.
33.1.
Uncorrected defects.
If the contractor has not corrected defect pertaining to a defect liability period under clause 32.1.1 and clause 32.2.2 of this condition of contract to the satisfaction of engineer within the time specified in engineer notice, the engineer will assess the cost of having the defect corrected and the contractor will pay the amount on correction of the defect. So now one is that performance security has been kept by them. 5% you keep that 5%. Now if this defect is not been cured by the contractor, so there is a provision where it will be forfeiting of those particular what is lying with you. They will notify, they have to notify. One, in this case, there is no notification by them. Why? I am saying because if your lordship now looks into the first RA bill at page 73 in package 29, see package 29, which is a type copy.
Page
73. 73.
Yes.
Now 73 is, see the pack 29 on the
Yes.
top.
Yes, I've seen.
Lordship has seen it.
Yes.
From this running bill, 5% is being deducted.
Security deposit.
Security,
That's
yes.
Roman 2, right?
Yes.
At the bottom.
Yes, the bottom. Secure depositing, so and so, 5%, so and so. Now this is one. Second RA bill will be kindly see 76.
So
76.
this is as per the contract, they are deducting it.
They are deducting from. So there are 3 RA bill which we will find at 76 and third is 79. 79.
Yes.
And after
So
this,
this was after completion of work.
now how do you find that this work has been completed? Please look into page 83.
Completion certificate.
Yes.
Yes.
So this is have been completed for the work of
Mr.
5
Das,
years.
I'm sorry, I'm interfering.
Yes, no.
Your case is about now they have not returned the balance security
Balance
deposit,
security,
correct? On the
yes.
ground that you are not maintaining.
I have routine maintenance
Is
has
not
not
done.
been carried.
Is not correct.
So is
But
not.
it appears prima facie that there is a clause in the agreement which bars deduction from the security deposit in as regards the routine maintenance is concerned.
Yes. Now there is another provision. How routine maintenance has to be recovered. If you see at page 37, that's the issue.
And otherwise, from page 83, you were trying to show that
this
it
has been
appears that
completed.
it has been completed.
Completed.
And there is
Now-
no objection or
No
anything.
objection. Now at package number 33, that is page 84. This is package number 34.
Yes.
Package number 33, my lord.
Yes.
So now if you see at page 86, kindly see 86.
No defect liability.
No defect liability. Now it 88 is the RA bill of 33.
Okay.
88.
Here also that 5%
Says
is there.
5%. Page 90.
5% in 88. Where is it?
If your lordship will find 5%
5%.
it is secured, that is secure deposit 2, same amount creditable deposit.
Where 2? Yes,
2.
yes. Statutory reduction.
Yes.
There. No.
Amount received security deposit after amount
I'm
creditable
sorry.
deposit.
Okay. I've got it.
Yes.
Here it is saying some
3.2 code FD. That's I have to find
But
out.
it is showing nil.
Yes, that's I have to find out why it is showing nil. But if you find at page 90, 90.
But in
Page-
the second page, 89, that 5% is there. See?
Yes.
Can you see?
89 5% is secure deposit there.
Yes. But in your
It is this
88,
is
I
but
don't know.
if you see
Even
at
90, there 5%
yes,
is there.
88 is the RA1. Kindly see at top 88 RA1.
Array?
RA1. The running account 1.
Okay.
Top.
Okay, yes.
This is one which I have not seen that 5%, which they have not mentioned, but 89 they have mentioned.
Yes, even 90 they
RA2, RA2
Yes,
on
I've
top,
seen.
5%, and 90 is RA3 on the top,
Yes, 5%.
which your lordship will find at 5%.
Yes, I have seen.
Then RA4 also, if your lordship looks into,
Yes.
RA4 at page 91, that is 5%. 5%. That is
yes.
secure deposit 5%.
Yes.
882, page 91. 882, secure deposit, amount credited.
88 doesn't have, but
That
otherwise
doesn't have,
the rest
yes.
of the pages it has.
92 has RA5, same security 5%.
Where 5?
At page 92, secure deposit,
Yes.
amount creditable
Yes,
5%.
yes.
So all this lordship will find.
These are typed copies are from 93.
Yes. Some type copy.
See, in your typed copy security deposit, that 5% appears.
Yes, 5% appears. You know, RA4. This is RA4 at page 93.
93?
RA6, 93, page 93.
Oh, RA4.
RA6. RA6. That 6%.
Oh, this is a different one.
95. 95 is that is the original RA6 with type copies at 93. 93. That 5% deducted. RA7 also 96 we find that there is a secure deposit which can be deducted 5%. 96. On the top you will find RA7, and where you find that secure deposit is 5%. So
RA8 also.
Yes.
Yes, I have seen.
96. 97 also RA8.
I have seen.
5%.
I have seen.
So all this goes on. Then, my lord, completion certificate at page 99.
Page
99. 99, if you see down below, Package number.
Date of completion as per tender agreement 12/4/2008.
Yeah, that's what 2008. So this is what has happened. Now we are not getting the amount that that RA bill amount 5% which they have kept with them. So we represented the matter before the authority.
RA1.
Yes, that is at page 67.
Yes.
Kindly see at page 67. With reference to 7, I have respectively said that so and so 29 final work order. I have duly completed the said work within time and according final bill has been prepared and released to me which I received. In the said construction work, some amount has been deducted to a secure deposit to which I am entered received back under condition of contract within 3 years after completion of the construction work. Unfortunately, I have not received the said amount even after expired defect liability period. In the above premises, I therefore request you, your good self, to kindly and take no and take any effective step to release my personal deposit at the time of signing of the contract. Also, the secure deposit amount deducted in my bill at the earliest, for which act of your good self I shall be ever grateful. So, two prayer has been made. One is the performance security, which has been deposited by way of BG. Another is 5% you have been deducting. Now, so far as
Mr. Das, let me just understand this 5% deduction when you're saying you're referring to the RA bill 1.
RA bill 1, that is package number 29, also package number 33. Now, if you see at page 68, this another representation so far to 33, package number 33. Same contention. So, before coming to the court, a representation was filed. So, we have to seek a mandamus. So, at least a representation has to be filed before the authority. Even then they did not pay. At page 69, kindly see page 69. This is what the executive engineer has written to the empowered officer. Submission of requisition of bank authority 50% SD money against the work. So with reference to subject side above, I have the honor to submit herewith requisition for bank authorization of 50% SD money is amounting to so and so for favor of your kind disposal. Now, my lord will kindly just note down that is the security deposit total comes to 10,37,661. We calculated, just note down package number 29, security deposit from 5% RA bill. When we add up all this total of RA bill 5%, it is 10,37,661. 50% as per that letter which I have read, that has been paid, which comes to 5,18,000.
This is paid.
Paid.
Remaining 50% is
not paid.
Not paid.
Yeah, that means remaining will be 5,18,831.
518830.
831. 5,18,000.
That is the figure here.
Yes.
Eligible for release.
Yes. This is in the first 29, package number 29. Now, your lordship will kindly note down just completion date, which I have just by the side, 10/12/2010, which your lordship has I have read page 71. 12/2010. At page 71. Yes.
It is at page
71, which I have already shown.
Yes.
It become easier for you. That's why I have given the date.
I have put it, yes. Complete.
Deducted from RA bill, page 76, I have shown. RA2, deducted page 79, RA3, deducted page 82, RA4. And detailed completion, your lordship will find at page 83. That no defect liability, page 83.
Yes, I have already marked
Yes,
it.
your lordship has marked it. Package number 33, not a single penny has been, that comes to 13,34,881. Your lordship will find at page 84.
84.
84.
Here also it was otherwise directed for
But
50%.
as per instruction, not paid.
paid.
That's it. They will have to clarify whether it has been paid. So now the word, now there are,
Post lunch?
yes. If that matter is the pertaining to the judgment passed by the court is on a similar line, after that here this 5
No, but
matters.
I'm
Yeah,
yet
yes,
to
your
hear
Lordship,
Mr.
take up.
Gogoi.
There are 5 matters.
I will not take much time. These are order matters.
No problem.
That way the councils,
No, it's no problem.
otherwise no point of keeping all the other councils waiting. So you just
Yes.
wait for 5 minutes.
Yes.
Yes, please call the order matter. Why is this for order? Service
Lordship, may kindly see.
service completed.
Lordship, Lordship, may court order.
It says completed.
Yes, Lordship, completed.
Like how?
My lord, I have a prayer. The issue is very simple, Lordship. Lordship, may kindly see.
No, but you see, it appears from 1411 that sometime in September it was served.
Yes,
No, it appears there is no representation. So I will fix it next week. Let us see. Office note dated 14/11/2024 indicates that service in respect of respondent number 4 stands complete. Stop. However, today when the matter was called, there was no representation on behalf of respondent number 4. Stop. List again after a week on a date to be fixed by the registry.
Oblige, Lordship.
150.
Why is it for orders? First time after notice.
I am appearing for 1 and 2, my lord. 2 requested me to appear in this.
For respondent?
2.
2. And Mr. Gogoi, you are for?
3, 4, 5, and 6.
3, 4, 5, and 6. What about?
This is central.
You are supposed to file some dusty affidavit.
Yes, Lordship.
Have you filed it?
Yes, Lordship, we had served the dusty, but the petitioner is unwell and going through some heavy.
How much time do you need?
Lordship, 2 weeks.
Mr. So-and-so, Learned Counsel for the petitioner seeks 2 weeks time to file the dusty affidavit as earlier directed. Prayer is allowed, list after 2 weeks on a date to be fixed by the registry. On top to be delivered, Mr. So-and-so for petitioner, Mr. A.K. Dotto.
Yes.
Learned Counsel for R2 and Mr. R.R. Gogoi for 3, 4, and 5.
3, 4, 5, and 6.
5 and 6.
I am 1 and 2, my lord. My lord, I am 1 and 2.
1 and 2.
Supplementary orders 55.
Affidavit appears to have been filed, Mr. Dotto.
Affidavit has been filed, but
Yes.
the same contention is there.
All right, then this matter will need some consideration.
Yes.
I'll post it next week.
Tuesday, Your Lordship.
Tuesday.
Tuesday, I'm hearing.
Next, my lord, any date after 10th, my lord.
Very well, yes, yes.
Very well, very well.
Any day after 10th.
Yes. It appears that the affidavit in opposition, as directed by this court by order dated 20/11/2024, has been filed today. Stop. A copy of this affidavit is also served on the petitioner through their through the engaged counsel. Stop. You have a look at it. In view of the above, list this matter again on
Any date after 10th, my lord. Good. Problem.
Highly obliged, Lordship.
56.
service completed. 3, 4, and 7. Not completed.
As per
No, it's completed. The problem is that you people don't even bother to go through the office note. If matters are fixed for orders, at least find out why it is for orders. What is the latest office note? Office note dated 20/11/2024 indicates that service in respect of respondent number 3, 4, and 7 stands completed. Mr. K. Gugu enters appearance on behalf of respondent numbers 2, 5, and 6.
Lordship.
However, there is no representation on behalf of respondent numbers 3, 4, and 7 today when the matter was called. A list again after 2 weeks on a date to be fixed by the registry. You want to file something?
Next time. Always.
Mr. Samaria, I think you will have to take another date for the hearing. I'm in
My
midst
lord,
of a hearing
I is
matter.
required. I is required to dispose of. There is a direction from the Honorable Court on 25 to dispose this. I is my lord only on one count. Proceed, kindly have a look to I have 3238 for a moment.
Mr. Samaria, please appreciate that this court is in the middle of a hearing.
My lord, no doubt.
Either you wait.
I will wait, my lord. I will wait.
Look, I have a submission. But our IA has been listed today. It has come for the first time.
Sorry.
We have filed an IA for seeking modification of the order. This has come for the first time today. The matter is otherwise it has come in under the column hearing column. But I would like to pray that if the writ petitioner wants to file any objection to the IA, let him file and Lordship will take up the matter on Friday next month.
My lord,
Which is your IA, Mr. Nath?
My lord, my IA is 3588. 3588 2024.
That is your IA.
That is
Mr. Samaria, your IA is 3238.
Lordship, kindly see first 3238. That will give.
I am posting it on Tuesday. In the meantime, anybody wants to file something, you file.
Can you take it out on Friday, if possible?
Why Friday?
I'm led by.
You've already filed your IA.
No, we have filed.
Thursday, my lord, better. Thursday.
It is
Thursday.
We have some urgency,
Thursday.
my lord. We have some urgency.
You see, Mr. Samaria is expressing some urgency, Mr.
My lord,
Nath.
thing is that
Thursday. You want Friday, we are giving in 1 day prior, Thursday.
But the difficulty,
What is the difficulty?
I'm led by Ladat AG here. He is out of station. He is coming back on Thursday. That is when on Friday.
Mr. D. Nath Leonard, Senior Government Counsel, submits that an I-3588 of 2024 has been filed on.
We filed on.
Has been filed, which is listed for the first time today.
Yes,
which is
on
listed for the
19/11
first time today, along with WPC 1013 of 2023 and IA Civil 3238 of 2024 under the column hearing. Stop. He further submits that he is led by Mr. D. Soikia, Leonard Advocate General, State. Stop. And accordingly seeks some accommodation in the matter. List again on Friday,
29th.
on such and such date for hearing of the three of the entire writ petition along with the along with the accompanying interlocutory applications. So I have set hearing for the entire matter. In the meantime, if any party wants to file any affidavit in the matter shall do so by serving advance copy to the other side.
I'm all right.
Matilda? I took 5 minutes, Mr. Das.
Yes.
Yes.
Nowadays, our days, those days, we have less matter. So hearing takes place about 4-5 days, 7 days. Now that we have 70-80 matters.
True.
Now we see in the Supreme Court also hardly it gave 10 minutes, 5 minutes to each of the senior counsel also.
Time is a constraint
Very,
now.
very important.
with
Now
the-
it's a different altogether. The system has changed totally. We have
But
seen
at the same time, the only thing which is required is that audience has to be given.
No, that's true. That's
but
true.
of course,
Audience has to be given.
always it is not possible for order matters and all.
Only difference what I found in the High Court and the Apex Court is the Apex Court is truly on the law. That's so where is the error that has been done? So it's so fast, showing the judgment in paragraph number so and so in between. But here is the facts and law.
Correct.
That is why it takes some time in the High Court. I have seen time in the High Court. My lord, now I have shown the details all. Now, I have seen the affidavit that has been filed by the government. Their stand is 33, they have taken a stand. They said,
Page 33.
No, they have taken a stand on the defect liability.
Clause 33.
33. What they have taken a stand, if your lordship looks into it, 33,
where taken a stand, specific categorical statement is at page 120, paragraph 6.
120.
120.
Yes, paragraph 6.
See para 6. That with regard to the statement made in para 5 of the writ petition, deponent begged to submit release of secure deposit at the end of the third year after completion of construction work is allowed only if defect notice and notified by the engineer are corrected by the contractor. In this package, however, the contractor did not carry out any routine maintenance work which has deteriorated the road and failed to provide intended service to the road user. Defects developed due to non-maintenance of the road during 5-year routine and maintenance period, which is also called defect liability period, are to be corrected at the cost of the contractor. In this connection, deponent begs to refer and rely on clause 33 of general condition of so and so. So, your lordship, that 33.1, see kindly 33.1, which has been read for your lordship.
You had already pointed out.
Now,
Yeah.
I found one section, if you see 32.1.1,
Yes.
in the the writ petition,
Yes.
that is page 34. Kindly see 34. 32.1.1 at page 34.
34.
34, page 34.
Yes.
Because if you see 35, that I have read uncorrected defects at page 35. 33, which two clauses has been referred, 32.1.1 and 32. Kindly see 32.1.1. The engineer shall give notice to the contractors of any defects before the end of the defects liability period, which begins at completion and ends after 5 years.
So it is a 5-year time.
5 years time, defect liability period shall also be extended for as long as defects remains to be corrected. Now, if your lordship looks into
32.1.
32.2.2.
Yes, routine
Now,
maintenance.
it is a different routine maintenance. Standards shall meet the following minimum requirement. So, these are the requirements which they have mentioned. But so far as the 32.1.1 is concerned, my lord, they said the engineer shall give notice to the contractor any defects before the end of defect liability period. Now, your lordship has seen, they have given a certificate that no defect liability, they have given a certificate. That which pertain to page 83. If your
No
lordship
defect
looks-
liability.
No defect liability. And we have never received any notice.
No, but Mr. Das, in case it appears that under the contract, the contractor has to perform routine maintenance for a fixed period of time, correct? Now, in case there is some failure, any consequence has been
Yes,
given.
that's what I want to show you. First, I want to say what is their stand they have taken. So basically, they have taken a stand saying that you have not done the routine maintenance work. So we have the right to forfeit that amount which is lying with us.
Where is that right?
Now I am telling you what they have done it. This your lordship will kindly see 43 again. Security deposit page
Yes, that is
37.
what I was thinking, because that is very clear.
No, 43. There is another.
43.1.
43.1 is very clear.
Very clear, but
that no secure deposit retention shall be retained from the payment,
from the payment
for routine maintenance,
maintenance work.
Now, number 2, or now 43.2, once you complete the period, how this amount has to be kept
That
by
is
them,
given, which you've
and how
already
to
read.
be released. How to
Correct.
be released.
Which you have
now,
read.
Now, see 43.3. This is your lordship note down.
Yes.
Additional performance security for unbalanced bids as detailed in clause 51 of the conditions of contract repaid to the when construction work is complete. That's a different. Now 43.4 is important. Your lordship will kindly mark down. Two things. Performance security equal to 5% of the contract price. Right, my lord?
Yes.
And additional performance security for routine maintenance as detailed in clause 51 of condition of the contract is to the contract is so and so to the contractor when the period of 5 years fixed for routine maintenance is over and the
So
engineer
there is
has-
there is additional performance security
correct. That's
also.
what I'm saying.
Now, what is this additional payment?
I told my client, I have asked, I brought him and said, "Yeah, you please because they are on the groundwork. They said initially when performance security, that's why I showed the first work order. If you see the work, see at page 19.
Performance security.
Performance security. So they say this performance security is on the basis of the construction work. They have to deposit by way of a bank guarantee. Then even that bank guarantee is released only when we complete the construction work, and 5% deduction will be there.
That is clear.
That is
now.
what.
What is this additional performance
Additional
security?
performance. Once your lordship will kindly see very
Is it
interesting.
defined anywhere?
No, I will
And
tell
that
you.
clause
No,
51?
I'll tell your lordship what normally happens in this case. This is a different head altogether, where the routine maintenance, some money has been different head. Kindly see at page 25.
Page 25.
See page 25. This is take instance. This is package number.
Yes.
Lordship got it.
Yes.
29. See that cost of construction. See the price has been mentioned.
20559750.
Now see the next cost of construction is this. Lordship got it? Cost of construction. There itself.
Yes.
25.
Yes.
Cost of maintenance. Sorry,
Yes,
cost
yes.
of maintenance.
151. So
Now on this maintenance, a work order will be issued. You have to give a additional performance security for this. This I have asked. Why? This is you have got a contract. Now what normally a contractor do? They have to give a work order of this, because this amount doesn't mention with the original construction work. Maybe I participated, I get the maintenance, I get a construction and maintenance. Now when I get a contract maintenance, routine maintenance, kindly see the price is different. Sorry, cost of maintenance. On this, additional performance security, once the work order.
So this cost of maintenance, you mean to say this is the routine maintenance?
This is a maintenance for a period of 5 years.
So this amount has to be paid by the contractor.
Work order to be issued, paid not 5% on this additional performance. Yes,
just
yes.
for my clarification,
Yes.
your client has to pay an amount of 1515750 as additional performance
On
security.
basis of this, additional performance security has to be paid. Like performance security on the total construction,
So
5%.
how much percentage?
It will be 5%, 15%.
5% of this amount.
5%.
But only thing, Mr. Das, where in the contract this is said?
No, what I am saying.
Does the contract say something?
No. Kindly see. Kindly 43.4. 43.4.
43.4.
Which I read.
Yes,
The performance
security
security equal to 5% of contract price and additional performance security for routine maintenance as detailed in clause 51. So let us look into 51.
51 is repaid to the contractor.
Yes, kindly see
when the period is over. So
50.
therefore, till now, I think we are on the same page. We all perhaps that there are two headings: one performance security and one is additional performance security. It appears that the performance security relates to the completion of the work. Once the work is completed, and if it is completed properly,
Yes.
then
security money has to be handed
how
over.
it has to be paid. How
yes.
it has to be paid is
It all has
provided
to
in
be paid.
43.2.
Yes.
As per 43.2,
Yes, correct.
it will
Right,
be paid.
right.
And there is a specific bar that out of that security deposit, it shall not be retained against routine maintenance work. Now, in case of routine maintenance work, it appears from 43.4 that there is another deposit which you contractor perhaps has made,
Yes.
which is under the heading additional performance security.
That's what
now that in terms of routine maintenance, as per clause 51, will be repaid to the contractor within the period of 5 years.
Yes.
Correct?
Correct.
If
Now
I have
it's-
understood you correctly.
Yes, correct. Now kindly see
Now
next.
let's see 51.
Together your lordship will 38, please read together. Then
Page?
38.
38,
We
yes.
read 5 years so and so.
Yes.
If If now the routine maintenance part of the contract is not carried out by
Okay,
the
okay.
contractor,
Yes.
as per this contract, the employer will be free to carry out routine maintenance work, and the amount required
For this
for
work
this work
will be recovered from the amount of
performance security
available
available with the employer and from any amounts of the contractor, whatever is due.
I think this
Please note
performance security should have been additional performance security.
That's that's your lordship will go to the judgment of the learned single judge. And that was never, I don't know, my learned friend will be able to say whether it has been put to challenge the judgment. Now, if the judgment has been put to challenge and there is some interim order, I am not sure, don't know also, then my lord, of course, situation will be different, my lord.
Because if subject to correction, the authorities must be acting under this subclause.
Yes.
Correct.
Yes,
This is your case.
Yes, that's the case.
Under this, because routine maintenance is not done, therefore you are recovering it from the performance
Yes,
security.
in fact, yes. That's done in the affidavit also. But
Yes,
I'll
you see, the entire clause has to be read together if one has to interpret the agreement. Correct.
Harmoniously, it has to be
Yes.
read.
Now, 43.4 talks about additional performance security for routine for routine maintenance. Now, in the subsequent clause, just because the word additional is not there doesn't mean from the performance security, because in 43.1 there is a clear bar.
And that I will clarify.
No, but I am simply saying, because you see, of
And
course, there are
three heads.
different way of
One is
interpreting
security
the
deposit, one is performance guarantee, and third is additional
Additional.
performance guarantee. So I will clarify
Now,
these three parts.
it appears to me that you have retained the power to deduct or not pay the additional performance security in the event the routine maintenance work is not being carried.
My lord, there was two parts of the contract. My lord. One is to execute the work of construction of the road, and the second part is to maintain it for 5 years.
Yes. Now,
So-
the performance security, that security
that's what I'm
deposit,
saying, my lord.
is
Yes.
relatable to the first part.
Performance security, my lord, is my lord, on the day when my lord, the letter of acceptance is given. So there is an amount given, considering a certain percentage, which is to be deposited by the my lord bidder.
All right, I'll come back
Yes,
to you.
it will be there in the letter
All
of
right,
acceptance.
let Mr. Das
Yes.
complete his answer.
Now, if we are reading this, 51, your lordship just want to see 51.
Yes.
Find at page 40.
This is like what you are giving by right hand, you are taking back by the left hand. It is something
Yes.
like that.
I also, one time I have asked, my lord, very honestly, let it be fair, this goes on that way is a different. I said, why don't, if the maintenance work is not carried out, definitely they will catch hold of you.
Some
This
consequence
is
has
some
to be
type
there.
of consequence has to be there.
Has to be there.
Either you do, because your contract is not only construction, your contract is a construction and maintenance.
Correct.
What happens? You don't do a
So therefore,
maintenance.
consequence
Some
will be
head
there.
will be there.
Will be
Some
there.
head will be there to recover it. You don't do it. Some other contractor has done it. So it is your fault. Let us be honest. I told that's your fault. How to recover? What is the mechanism to recover? That was debated before the learned single judge.
All right.
That's why learned single said absolutely no problem. Maintenance, security is of course two things. If you want really to recover from him on the basis of maintenance, first that a notice has to be given. One, why you have not carried the maintenance, and why we should not recover this particular amount. Why he has not
In your
done
case,
it?
the notice was not given.
Not given. That's what the view of the learned single
But
judge.
before that also, this has to be also looked into whether at all from the performance security that
No,
can
that's
be.
why I have pointed out. I have pointed out something I got yesterday. That's why I thought. So these are important. There is some ramification. Government has to be, public money has to be looked into. All these are there. So I thought that I will just point out these points. This how to recover, when to recover, whether they can recover on this. What I found, I told that whether a separate work order is being issued, then he showed me this is the head where routine maintenance you see on the page. I found yes,
25.
Where that amount has been given. Now
15157.
that they said a work order is issued on the basis of it. There is a demand made by the department. This is the work order. This is the amount for a period of so and so. Additional performance security. You have to now give us that bank guarantee of the additional power.
Any document?
No,
whereby-
they didn't get it. That's the whole problem. Now my learned friend has to. This is what I have my client instruction. He has to tell the court that whether this procedure is being followed or not. I am telling you very honestly, this is not being decided by the bench. This is only simple. We have gone to 43.1 has been read, 43.2 has been read.
No, because
40
it appears there are two headings.
Two headings.
Performance security and additional performance
Yes.
security. Additional performance security is linked to routine maintenance.
Yes.
Now, in that situation, how can they deduct it from
No,
performance security?
that's what I'm saying. But if you read at page 19, page 19, once again, you'll find very interesting. Pursuant to a fund is requisite performance security. Also, got the first and so and so, and routine maintenance. How you read? Whether you can read together that it is a
It is not
construction
together. It
So
is not
routine, performance security, routine maintenance are two different heads. No defects are
As of
that's-
now, I'm yet to hear, Mr.
No,
Gogoi,
that's
but
what
it
the-
prima facie appears there are two
That's
different
what the
situations.
view of that court by which I appeared. But I found something, these paragraphs, that's why I thought that I will just put it before the court.
Correct.
Before the court.
Let's
So,
say 51.
51, kindly see at page 40.
Yes.
51 is operating and maintaining maintenance manuals. 51.1, if as built, drawings and operating and maintenance manuals are required, the contractor shall supply them by the date stated in the contract data. 51.2, if the contractor does not supply the drawing and or manuals by the date stated in the contract data, or they do not receive the engineer approval, engineer shall withhold the amount stated in the contract data from payments due to the contractor.
What is contract data?
Contract data is, my lord, lordship will kindly see it
Apart
in
from the
defined.
bidding documents, any other manuals or guidelines is there, Mr. Gogoi?
There is a manual otherwise.
There is a manual.
But the contract data only specifies the scope of contract, when it is to be completed, how many months. There is
Yes,
given.
contract data is defined.
Yes,
Contract
it is.
data defines the documents and other information which comprises the contract.
Yes.
Yes. So
Now-
contract data defines the document under information comprising contract at page 49. General condition of the contract.
No, 26 also it is there.
Yes, it defines 26 also.
Anywhere the additional performance security or performance security is defined.
Yes, it is there.
Where?
It is in clause 46. That's what I wanted to point out.
Clause 46.
46. 51, I suppose. or 51.
46 is security.
Performance
Yes,
security.
Lordship will kindly go
All
to
right.
46.
Mr. Das, let's read together.
Yes, 46
At
securities.
page 39.
46.1, 39.
Yes.
Performance security equal to 5% of contract price and additional security for unbalanced bids shall be provided to the employer no later than the date specified letter of acceptance and shall be issued in the form given in the contract data and by scheduled commercial bank. Performance security and additional performance security for routine maintenance shall be valid until a date 45 days from the date
So
of
this
expiry.
also shows that two different things.
Two different. This or defect liability and the additional security unbalanced bid shall be valid until a date 45 days from the date of issue of the certificate of completion. If the performance security is in the form of bank guarantee, the period of validity of bank guarantee could be 1 year initially. However, the bidder contractor could get this bank guarantee extended in such a way that the amount equal to 5% of contract price is always available with employer until 45 days after the lapse of defect liability period. If the bidder contractor fails to maintain above performance security, employer would recover the same from the dues payable to the contractor. This is unbalanced bid is a particular bid which is more, it's a lesser, but it is unbalanced, a lesser, then you have to just put that additional performance security. That's what I have
Yes,
understood.
yes. In fact, yes.
That's what I have
happened is, my lord,
understood.
there is a circular of the PWD that, my lord, in case of the tender works, one cannot go beyond minus 10% of the bid price, contract value, or say plus 10% of the bid value.
Anyway,
So
that,
supposing
that
that's
I
why
don't
the
know.
unbalanced part comes. Supposingly, my lord,
Correct,
the
but that
contract.
has no relevance otherwise here.
Yes, that's
because
explaining, my lord, why
What
additional performance
unbalanced
is
bill is,
required.
suppose I quote a price,
Yes.
but that quoted price, it appears that is an unbalanced bid I have quoted, then I have to guarantee them by giving an additional. I think that's what
Yes, like, my lord, 100 rupees is the,
I
my
have
lord,
just
contract
done
value.
So that
Somebody,
is, in case there is an unbalance,
here
bid,
then
it is
then you have to give a
just like the
additional
L1,
security.
yes,
But you
somebody
see,
quotes-
this is part of that performance security only.
Yes.
Now, because the second sentence.
Yes, it is additionally one
correct,
amount is to be
but that is part of the performance. That's why in the second sentence, two things are said: performance security.
Yes, sir.
This is one, and additional performance security for routine maintenance.
This is what
This
they
is the second.
exactly. This is what they said.
This is second.
Otherwise, they will never mention.
Because you, and everywhere you are using the word additional performance security when it comes to routine maintenance.
Yes.
That is why one thing which still is not clear in the mind of the court is, what is this additional performance security? Which part or which clause in the tender or in your guidelines says that an additional, apart from the performance security, the contractor has to also deposit an
46,
additional performance
46.1.
security?
46.1.
46.1.
Yeah, it says so.
No, where does it say? It says shall be valid. Now, what is, how do you, it only talks about the validity.
No, that's nothing about additional performance. That's why when I read this clause, I called the client and asked him, what is the additional performance? He said, the amount of the construction as well as the routine maintenance, that together they doesn't club together. Once you complete, the period is over, so for the construction, performance security as well as the money is
I
returned.
am appreciating what you're saying, but since it's a
Not very
contract,
clear.
it has
Some
to
clause
be,
will have to be there.
it has to be there somewhere.
Yes.
It is
Because
there,
the rights
broadly,
and
my lord, we are not
liabilities
able to
will have to flow
This
from
will
the
have to be
terms
here.
of the contract.
Yes, yes, we cannot go beyond the
We cannot
contract.
go beyond the contract, and the contract is making very clear that there are two things.
My
And
lord.
when it comes to routine maintenance, it is used as additional performance. And in that clause, it says additional payment will be repaid within 5 years if you are doing the routine maintenance in terms of the contract.
My lord.
But in the event you are not doing it, then
Right.
it will be forfeited.
My lord.
There, the word additional for some reason has been left out.
Yes.
Now, this the court can read it because
Correct.
it appears one has to construct the agreement as it is understood by
My
both
lord.
parties as well as
I
in
don't
terms
know,
of the
while-
other clauses.
Correct,
That I
absolutely
will
right.
have to
Correct.
clarify.
And
Now,
secondly,
everywhere it
correct.
is additional performance
My
security.
lord.
Suddenly, in that clause, additional is missing.
Yes.
But that doesn't mean it would be only performance security. Till there, Mr. Das, I am
No,
clear.
no.
But only thing I am not being able to appreciate is that means there has to be something more which you may have deposited, which is taken as additional performance security.
Yes, that's right.
Because that is the amount they will
I just
not
that's why
repay.
I just asked my learned friend, with your lordship permission,
Hmm.
that what is the procedure so far as the routine maintenance is concerned.
Mr.
Whether
Gogoi,
number
I think
one,
you will have to clarify all
number
this.
one, why I'm saying these have a ramification of other case, my lord.
Yes, yes.
The ramification of other case. Maybe that point has not been decided. I'll just
Maybe it was not taken up.
Yes, that's why
Yes,
I
that was
thought.
only security deposit was there.
My
in
lord,
that
what
case.
I thought that I should tell your lordship, once I read the entire, I said this may be maybe this way or that way it goes, but it should be a settled law so far as the maintenance part is concerned. My learned friend can take, my lord, let it remain as a
Yes,
partner
yes,
because
it will
this is a
remain.
ramification. One, that whether for routine maintenance, whether a work order is to be issued to a party. I think, my lord, I don't know, subject to how the court takes it. Routine maintenance, whether a work order has to be issued. In pursuance to work order, a notice has to be given. Even you got the job of construction as well as routine maintenance, whether it is number one, a duty to inform the contractor, look here, this is a drawing, designing, whatever, routine maintenance. Now, this is the work order has been issued to you. Please pay us additional performance security of this particular work, whether that is required or not. So far, a routine
This part
maintenance
would have been
concern.
clear, my lord, had the, my lord, letter of acceptance been annexed to the writ petition.
You have it?
On, no, my lord, it will be mentioned there, that
I
you
will-
pay the performance security so and so and additional performance
Where
security.
is it? You
I
can
can
have
place
the-
it, my lord, I can place
You
it.
can place it
Because-
then?
Yes, yes, 19
Then I
and
will-
20 is only the, my lord.
Then I will keep the matter part
Yes,
right
yes,
and
my
I
lord,
will
should
direct
be.
you to
Otherwise,
produce
I
the
can,
letter of acceptance.
yes, I can refer to various
If the
provisions.
letter of acceptance does not clarify, then in that event you get
No,
the
no, my lord, I will
clarification.
have the
See, Mr.
instruction.
Gogoi,
Yes.
because I think you need to show
Yes, yes.
what is this additional performance
Lordship,
security,
lordship,
because it
my
has been used. It is not something used alone. It is used together with performance security. And that 43 clause clearly says performance security you cannot retain for
Yes.
routine maintenance defect. That is there.
No.
Yes, yes.
No, no,
for-
security deposit.
Correct.
Security deposit.
Performance security. You see, security deposit 43. What is a
No,
security
no, it's
deposit?
security deposit.
Security deposit would mean your performance security only.
No, it's different, madam. That's why, madam. 43 speaks about security deposit. 46 speaks about, madam, performance security and additional performance security. So there are three hats.
No,
madam.
but even in 43, if you come down,
That's why, Lord, you will see, my lord. It says,
you
my lord, there
come
no.
down to 43.4.
I
Come to 43.4, Mr. Gogoi.
Yes.
Performance security equal to the 5% of the contract price and additional performance security for routine maintenance.
Yes, right. And I found
As
out.
detailed in clause 51 is repaid. The word is repaid.
And one more thing, my lord, to my lord, point out, my lord, the last line of this, my lord, Lordship is pointing out, my lord, 43.4. Lordship will see
Yes.
the next page is to be repaid to the contractor when the period of 5 years fixed for routine is over.
maintenance is over.
And my lordship will see the last line. And the engineer has certified that the contractor has satisfactorily carried out the routine
So
maintenance of
this
the work.
that is what I'm
My
saying.
lord, in the present case, in our affidavit, no submission has been made from the other side. But my lord, we have made a categorical statement. This particular certificate has
not
been
there.
cancelled by the engineer, my lord.
See, be
So
that
without
whatever. See, Mr. Gogoi, that is the step,
Yes,
next
yes,
step.
yes.
But
To
before we
understand
go
it,
to
my lord,
that, first and
I will
foremost,
pray for only, my lord, a week's time or any day convenient.
what is to be retained? Because Mr. Das has very fairly argued
Yes, yes, yes.
that he agrees that if there is some non-failure of performance,
My lord.
obviously the contract will fix some
My lord.
consequences.
And lordship
That is
will
how
see,
the
my lord,
contracts
we
are made.
all are aware, my lord, considering the weather condition of our state. 5 years, my lord, a concrete, my lord, road.
Mr.
There will
Gogoi.
have to be some maintenance. It's not that, my lord, it
Mr.
cannot be a
Gogoi,
single
neither
pothole.
Mr. Das nor this court has any doubt about
Yes,
that.
yes.
But
So-
there has to be a procedure.
Yes.
What is that procedure?
My lord.
Because as far as appears from the papers,
But that I can place, my
performance
lord.
security is different.
Any
Additional
day
performance
convenient.
security is
Otherwise, my lord, I
different.
can relate to some,
And
my lord, clauses.
Right
which will
now,
further-
you have not repaid the performance security for which this court, for
Yes,
which this
buffer
case has
security
been
running account,
filed.
yes,
Correct.
No, my lord,
We
our
have
affidavit
kept-
says the
we have-
security deposit. We have retained the security deposit. That is what our affidavit says.
Correct.
So I will have to clarify,
But
my
you
lord.
see, you
Otherwise,
can't
clarification
retain
will
the
be necessary.
security deposit for non-performing of maintenance. 43.1.
No, there is a provision, my lord.
Where?
Yes.
43.1 it says no security deposit
43.4,
retention.
Lord, you will see 43.4, the second para.
Mr. Gogoi, that second para,
The last line, my lord.
last line cannot be read in isolation.
Yes.
It has
But
to
it
be
says, my
read.
lord, or from any amount of the contractor wherever is due. Even if, my lord, security amount is due, my lord, from that also we can deduct. After
But
all, my
then
lord, public money.
43.1,
Yes, I will clarify that today,
there,
itself, my lord.
why I
read
am
it?
repeatedly bringing your notice to 43.1
May I
because
clarify it?
there is a
May I
bar.
clarify it, my lord?
You see,
No,
there
there
is
is no bar, my lord.
Then-
There is no bar. I will
Why?
clarify. The employer, may I read it?
Yes,
the
yes.
employer shall retain 43.1. The employer shall retain security deposit of 5% of the amount from each payment due to the contractor until completion of whole of the contract. So it will be a deduction. Now, Lord, you will see no security deposit or retention shall be retained from the bill. It's regarding deduction again, my lord, for routine maintenance of the work. It's not said that, my lord, we cannot deduct it. It says that for the purpose of routine maintenance work, you cannot deduct additionally
That is
5%.
exactly. Now you are deducting it for routine maintenance only. You are saying he's not doing routine maintenance.
No, that's why, my lord,
No,
43.4.
but is
Now
that
we'll
not
have to
your
see.
case?
We'll have to see 43.4.
Yeah.
Performance security equal to 5% of the contract price and additional performance security of routine maintenance as detailed in
So
clause
that
2.
so if from the very first one from the first sentence, is it
My
not clear that there are two things?
Three
One
things.
is
My
performance
lord, there are
security,
three things. Security deposit,
performance security,
additional
and additional performance
My lord.
security. Very well. Now it talks about two things: performance security and additional performance.
Lordship.
Now, when it comes to routine maintenance, what is it? What is being used?
Performance security and additional performance.
No.
Yes.
Performance security is different. And because the word "and" is there, it is not an alternative. The word "and" separates the two words. And performance security is used for routine maintenance.
Yes, yes.
If Mr. Gugoi, if you think there is another perception, you can
I will have
present
to,
it.
see with
You
the
can
authorities.
definitely
Yes, yes.
present it to the court. But
Fine.
at this moment, I have a feeling this is the proper construction, whatever I have
Yes,
seen.
but everything will go subject to what my learned friend says. I found somewhere in my judgment of the Supreme Court, just my learned friend has pointed out, for routine maintenance, does a work order has to be issued for routine maintenance? Yes, a work order is required for routine maintenance.
So a work
I
order
will
has.
just see.
So you
I am
show
not-
you produce the record.
No, I can, my lord, but today, my lord, when the work order has been issued, one work order, he has completed it. After 12 or 13 years, he comes and says, my lord, there is no work order for routine maintenance, and I should not be deducted this so
but
and so
how
money.
do this court
Can this, my lord, be
adjudicate?
considered
This is-
today?
Today I am
That is the
asking.
subject matter.
No, even then, my
The
lord,
entire
the work
issue
was,
is your routine
no, my
maintenance
lord,
now.
Lordship will have to consider, my lord, this is a case relating to a contract.
Understood,
Now,
Mr.
after, my lord,
Gogoi, but if
in
this is the
2010
issue,
and 13, my lord, the work was completed. We are now, my lord, after say 13 years or 14 years, you come before this honorable court and you say
when did you? When was that?
work was one was completed in 10 and I'm
Correct,
13.
but obviously the cause of action has arisen only when you have not cleared the.
No, my lord, after
It
5 years.
doesn't
5
go.
years.
Huh?
5
It
years.
doesn't go. That remains. Even today, when the learned
2018, my lord, is the last one, my lord. 5 years.
See,
kindly
Mr.
see.
Gogoi, one thing is very clear. In order to adjudicate this writ petition,
We'll have
the
to, my lord, clear
procedure
education. Yes,
has
yes.
to be understood.
At least for this
Unless and
honorable court.
until I
Yes, yes.
understand the procedures, how do you
I
expect this
understand.
court to
So I'll
offer a
pray for a
judgment?
date, my lord, any day
Correct.
convenient.
Now, in order to assist the court, you must
Yes,
show
yes.
whatever is there.
I will lay down the entire procedure.
But
Yes.
only for a moment, kindly see 131, page 131 of their affidavit. 131.
130?
131 of their affidavit.
Last page. Yes.
Yes.
Last page. You have seen 1, 2, 3, my lord, 29 package. Why at 131?
Yes.
131, 29. This is
Yes.
package number.
Yes.
That's what I have said.
Yeah.
33. These are to the subject matter of the case. Subject matter of second is 33. That is also subject matter.
The package.
See number 3 is 49.
This is different.
Now that is why that package, now it was given to whom? Kindly see on the remarks. Defect correction was executed by another contractor and rupees so and so, utilizing forfeited SD money. Right? Now you see the
This SD
49
money is
is not a subject.
your
no. That's what I'm saying. See the at page 146. See 146 reply. This is our reply.
146.
146. Our
146
reply.
is Muslim Ali case.
Yes, that's the same
Okay.
person.
Okay.
That's the same person. In another repetition, see 147 first, second paragraph.
Yeah.
So and so and
49.
49.
49.
That's the same. 3 package. This was under challenge before the court in the year 2022. And the finding of the learner, this is Nalbari district. Now what is the finding? Kindly see the finding. Finding of the 12
Yes.
at 149.
Yes, I have it.
See, non-performing of other part of the contract work for routine maintenance would be a violation of the terms of the contract by the petitioner contractor. And for such violation, petitioner can be subjected to a procedure under any relevant provision of law that may be available, including any such penal provision that also may be available for non-performing a particular requirement of a contract work. But at the same time, security money that has been forfeited is directly related to a part of the contract work or construction of the work, which work, even according to respondent, otherwise been satisfactorily performed, and further no defect therefore could be pointed out by the respondent so as to entitle them to deduct the secure deposit.
From such point of view, we are unable to accept the stand of the respondent that as because the other
This
party
is division
contract,
bench.
the single bench, coordinate bench, for performing the routine maintenance work has not been performed by the petitioner, therefore the security deposit which pertains to the part of the work of concerned road or also liable to be forfeited. Accordingly, we direct the respondent to pay the security deposit pertaining to the part of the
I
contract
don't
work.
see as of now any reasons to differ from this.
That's what I
judge,
found.
decision.
I will,
Mr.
my lord,
Gagan.
defend.
I'll give you
I
the
will defend.
opportunity. I'm not deciding today, but I am merely
yes.
expressing so
Lordship.
that
Fine.
you see you prepared in that manner.
Now, if
Lordship.
my learned friend can place before this court and your lordship finds that I do not agree with the order of the learned, then it can be deferred to a larger bench. What I thought
No
that
question of my lord.
this
I will, my lord, place on facts of this case, my lord. I will defend you.
no, that's
Not on
what
the law.
No,
It's
that's
the
what
law.
I'm saying. The law on
No,
the
no.
facts. These are three heads which they have already done by
Appears
other
to be.
contractors,
Appears
which
to
I have shown. Now, on law, what I, with great respect to my learned friend, on law he has to say, not on facts. Facts is very clear. Now, the same facts which was argued before the coordinate bench was routine maintenance as well as the security. That's the law, ultimately. Can you recover from a security deposit under 43.1? That's the
This
whole
is what
case.
you need to actually
That's
answer.
what has to be answered. And my lord, what
because
I
you
found
have forfeited the security deposit.
That appears from the affidavit.
now, my lord,
Yes.
I have not come across. There are so many cases which I have not really. I went yesterday. Always, my lord, your lordship will find a construction and maintenance, two heads. Now,
That
whether
is very
that's-
clear.
Now, whether just I thought of placing it as per instruction client that whether a work order is being to issue. Now, I find one of the the one judgment, my learned friend is a subject. I have to go through entire judgment. I will not place something which I don't go through it. Every paragraph has to be read. So they said work routine maintenance also, yes, a work order has to be issued. Then the whole issue will be something else. Then every case, routine maintenance, they have to issue a work order. Then you cannot.
In this case, as per the instruction of your client, was
that-
was work order separately
No,
issued?
no, it's not,
Not
issued.
issued.
That's what my instruction. Then I told, what is that? He said, on the basis of the work order, so far as the routine maintenance, they issue a letter for additional performance of security.
That is at 25.
BG has to be submitted to them to secure it. So that tomorrow, if you run away in between, they will catch on forfeit that amount. That's the requirement.
That is the additional.
Additional. That's the requirement. Suppose I run it.
Even my common sense says it should be something like that. But the difficulty
Yes.
is that the
This also
contract
I don't.
is silent.
Yes, that's what.
To that part.
My lord.
To the additional.
Yes,
to the,
performance security.
yes, because it indicates that these are the two different headings.
Why it is to be deducted for
Yes,
what purpose?
what purpose?
That
I
is
will
left
allocate.
silent.
And what I just request my learned friend that if he can get that hold of, whether for routine maintenance work, a separate work order has to be issued or not.
No, man, there is no such separate work order.
This
So
is
what-
what
whatever I have
he can-
come across.
He has already submitted.
That's very nice, my lord. I'll just go through some judgment that whether for routine maintenance work, what is the law that has been laid
So
down.
that is one thing, my lord.
Mr.
Today, whether
Das,
that can be deliberated. My lord, it's not the case.
Each of the cases would depend on the context of the contract. Ultimately, it is the contract would determine generally how it has to be done. So first and foremost, I think we have to understand as per the as per the subject
correct.
contract, read with the guidelines if any manual or anything is there. If there is something,
Yes.
because they will this routine maintenance and that additional performance security cannot simply be stated without having any meaning. There has to be something given, some meaning has to be given to the word additional performance security, because as we have seen, it is used together with performance security and it's separated by end. So obviously there are two different situations.
But when the question of a legal issue has been propped up before the court, after 10 years also you can look into it. There's nothing.
Mr. Das,
If they come up,
this court will not go into
no,
all
what
that.
I'm just saying, no,
Since an issue seems to have
limited for
arise,
the security deposit.
this
no,
court will
suppose,
go into it.
my
or
lord,
forfeiting of-
that's true, my lord. There's true. We are on
whether from the routine maintenance whether they can forfeit for the security, which
That
is
is the issue.
43.1.
That is the
That's
issue.
the whole issue. Which are the coordinate bench also said you can't do it. That's the end of the matter, coordinate bench. And suppose my learned friend wants to impress the court by showing some other provision or interpreting that will be a different issue altogether.
I suppose Lordship will be sitting in the division bench next week. So any day convenient, my lord, will do it. Huh? At least 10 days may be given, my lord, so that I can at least sit with them and understand the entire issue.
Heard the matter in part. It appears that the records, you will produce what?
I will produce the instruction as well as my lord, entire procedure of deducting and utilizing this particular performance security and additional performance security. That part
During
also
the
will
course of hearing, it appears that the issue involved in this writ petition is as to whether the security deposit submitted by the contractor stroke petitioner can be forfeited for not performing the subject routine maintenance work.
Right.
Stop. It further appears that the contract is silent as regard the procedure for depositing the additional performance security, which appears to be in connection with the routine maintenance work. Mr. Gogoi, learned, you're appearing as
SCPWD.
the Learned Standing Council, PWD, shall obtain instruction as regards the procedure for granting work order work order for routine maintenance work. For granting routine maintenance work,
That is not the issue, my lord.
it will be required. You find out
That's a
along
finding
with the procedure thereof. Stop. He shall further produce the letter of acceptance pertaining to the subject work orders. Stop. Anything else?
That's
My lord, that's only that part. Anything else, I will come up with everything, my lord, relating to this particular issue.
The records are there.
Records, if necessary, my lord, I
You
can
keep it.
Yes, I will keep it.
In Mr. Gogoi shall further keep the records pertaining to the subject work
Yes.
available on the next date of listing. Stop. List again after 1 week on a date fixed by the registry. I'm giving that liberty to the registry because
yes, of course.
the day this bench is available, they can then
Yes,
fix
yes.
it. All right.
Yes.
But both sides will have to give something in some synopsis. So you can prepare that also if you want to, Mr. Das.
We'll give it.
I have taken note, but it would.
Yes, I will definitely will give it.
It shall, and also if
Or
you
my lord,
can.
if something is there, if anything is required to be placed on affidavit, so the other side can go through it. Anything. If that liberty also is given, my lord, that I can.
Matter is
Let it be now as it is. and
If
your
you
lord-
have something, we will see that.
Lordship.
You are having the records.
My lord.
What else can you do now? The records will speak for
If the
itself.
liberty is
You
given without any
want to
objection
point
from the
out
other
something,
side,
you can show it from the records.
Lordship.
We will see that.
At least they will get the chance to reward, my lord. That's why I'm saying.
Pleading stage is over, Mr. Gogoi.
So that's why I'm seeking the liberty.
Hearing
my
this
lord,
matter
without-
now. So